LCA received or not?
Lordship, last when the notice was issued, Lordship, upon response number 2, which has not been served yet, Lordship. Notice was issued upon response number 2.
It's served or not?
Not yet, Lordship. We have not
There
received.
is a report.
We have issued notice through PP office, but we have not received it.
Report has come, probably. Is it from Bomdila?
Yes, my lord.
He could not be found.
Lordship, if I may. Lordship, if I may. If I may, Lordship, submit, if I may submit it, Lordship. Lordship, on the last occasion, I believe, Lordship, the brother of the victim, the complainant, has approached and with the notice. But it was apprised to this honorable court, but the court has directed that a formal acknowledgement may be submitted. So on the last occasion, they had appeared, my lord.
They appeared.
They had appeared. So, Lordship, it was our prayer. Lordship, this matter has been pending, this IVF and IA for suspension of sentence. This is awaiting the receipt of notice by the victim, Lordship. So, Lordship, can an amicus be appointed on behalf of the victim?
I'm also thinking about that.
Amicus may be appointed, Lordship.
Discipline. Heard Mr. G. Tallo, appearing for the appellant. Heard MS L. Hage, the learned edition of public prosecutor for the state of Assam. Service of notice of the respondent number 2 is yet to be complete. Mr. Tallo submits that in order to speed up the process of hearing of this appeal, an amicus is required to be appointed to represent the respondent number 2. We have considered the submissions made by the learned counsels of both sides. This court has decided to agree with Mr. Tallo. Time song.
Lordship.
Amicus.
Lordship,
You'll be the amicus here.
yes,
The learned counsel, Mr. Tayum Son, shall be appointed the amicus curiae to represent the respondent number 2. Mr. Son is present in the court today. Then you go through the record. Paper book was supplied to.
Lordship, as per record, teacher has already arrived, so paper book may be prepared, Lordship. Teacher already arrived, Lordship.
Registry directed to prepare the paper book. Copy of the paper book shall be provided to the amicus curiae. You need
All of us, Lordship.
to the amicus curiae along with the other two learned councils. List after 4 weeks.
Lordship.
Lordship,
Obliged,
a
Lordship.
small prayer, if it could be considered, my lord. Lordship, or when paper book is being prepared, paper book, it may take time, Lordship. We have an IA. Can it be listed after 2 weeks, Lordship? The IA. It is for suspension of sentence, Lordship, and the paper book may take some time for preparation, my lord.
The connected interlocutory application shall be listed after 2 weeks.
Much obliged.
Obliged.
May I plead your lordship?
Yes.
Well, in this 2 and 3, basically this 3 is a PIL, it's a division bench matter, and 2 is a single bench matter. Your lordship, in fact, this writ petition was filed, and then as per, I think, council lawyer is here, they want to refer some affidavit of PIL. That's how it was taken together. Now this PIL has to be heard separately, in fact. That was as per the view of your lordship. And in this PIL, we have filed, the pleading is complete.
The stone crusher is already closed.
As
Hello.
per, there is a 2 stone crusher, as per,
Lord, in fact, what happened? Writ petition, item number 2, writ petition. That has been filed because since one PIL is pending here, there is no interim order, and one case is pending before the Green Tribunal. So, in view of 2 cases pending, the department has closed this stone crusher. For that reason, the writ petition was filed. Yes. Otherwise, there is no interim order either in the NGT or in this PIL. But because of pendency of 2 litigation, so this stone, the writ petition has to be filed. The order has been given to close down. Now, otherwise, if we can argue on this PL, main PL, then we have already filed. Let him argue.
we have also filed a rejoinder. Well, it can be fixed for the hearing. Now it's for admission, let matter be admitted and it can be fixed for hearing.
Okay. Pleadings are complete.
Pleadings are.
Pleadings are complete in the PL.
In the PI.
In the PI.
Yes.
The item number 3. Heard Mr. S. Moore. The learned counsel appearing for the petitioners. Heard Mr. P. Patil. I forgot your name.
My lord,
N. Ratan.
N. Ratan.
Appearing for the. You are appearing for.
I'm appearing for 1 to 8, my lord.
Additional Advocate General.
Yeah,
Appearing
1 to 4 to 8.
1, 2,
4 to 8.
and 4 to 8.
Yes, ma'am.
Talo is home.
On behalf of Mr. T. for respondent number 9 and 10.
Heard Mr. Ruchi Talo appearing for the respondent number 9. Pleadings are complete. When do you want it?
Maybe after 2 weeks.
Let's get after 2 weeks for hearing along with item number 2.
My lord, let it be fixed date, my lord. Let it be on 7th.
April.
Yes, ma'am.
7th April, along with item number 2. Number 4. You will stay for hearing.
Lordship, this matter may be fixed for Lordship, hearing Lordship, that services of awaited, and it was also taken a fresh step, and according to submission of the PP, last date also I had taken again step, Lordship.
Oh, this is a Bhalukpung matter.
Yes, Lordship.
Yes, sir. Service not completed because
The
the
man has left.
yes, he is actually from basically from SEPA actually, Your Lordship. But the
Because
notice was served in the PS of
temporarily
police.
residing in Bhalukpung.
Yes, Your Lordship.
Now his whereabouts is not known.
Not known, Your Lordship.
Amicus will be appointed.
Amicus may be appointed and yet this matter may be released for Your Lordship hearing after review break, Your Lordship, after 4 weeks.
Hard Mr.
HT Tara, Lordship.
Titara. Appearing for the appellant, hard Mr. T. Ate, the learning council appearing for the state of Tamil. Anyone? Jinita,
Yes, Your Lordship is present.
the learned council, Mr. Gimita. Oh, hard say additional PP for state of Assam. Para. It has been, from the record, it appears that the respondent number 2 is not available in the given address. Therefore, the learned council, Mr. Gimita, is appointed the amicus curiae to represent the respondent number 2. Paper book is already ready. A copy of the paper book shall be provided to Mr. Tara. This matter for hearing when?
After 4 weeks, Your Lordship.
After 4 weeks.
Deeply obliged.
कोई मेंशन कर रहा है
May I please, Lordship?
Yes.
This matter was endorsed to the additional PP Jitado, but due to his health condition, he has not turned up today. So kindly, this matter may be taken up after break, Lordship.
my lord here my lord this IA my lord is still pending my lord and my lord case is something like that my lord during the trial my lord the parties have married my lord they have a my lord child also my lord the 1-year-old baby my lord and the victim this complainant my lord she is in my house. So as per the customary, we have married and we are together, my lord. And my lord, apparently even judgment also, my lord, so for finding of the age, my lord, there is wrongly there has been, my lord, determined this age, my lord. This is something consensually it happened because of misunderstanding. Subsequently, FIR was filed, and before my lord conviction, they married each other. And there is a child also, my lord. And more than 1 year he has been in the custody. And they need to be supported also. Child is there, wife is there. And this is the problem, my lord.
Yeah, what about, um, who is-
Victim is,
Yeah, victim. You want to say something?
The Lordship, it's fairly submitted.
Hmm.
We have already solemnized our marriage as per our customary rituals.
Okay.
Plus, on the, your Lordship, I would like to submit that, my father-in-law, the father of the present academy. It's a heart patient and he's about 70 years old now. I'm staying with the father-in-law's house. It's becoming very difficult for me also to sustain the Lordship and take care of the family.
No, it's considered I today.
my loss.
Heard Mr. R. Sonar in the I.
Aye.
If we for the applicant. Heard Mr. I forgot your name. Your
Please
name.
read it.
No, his name, new public prosecutor.
Yes, Deloy.
Deloy. The learned public prosecutor for the state of Arunachal Pradesh. Heard Mr.
Please read it.
He's saying, appearing for the informant. But this application is filed under section 389 of the Code of Criminal Procedure, praying for suspension of sentence and for releasing the applicant from bail. Para. The applicant, Pema Dajangju, it's side of it. Was sentenced to undergo imprisonment by the learned special judge POXO West Coming District in POXO case number 04 of 2022. Now the learned counsel for the applicant as well as the informant have submitted that the applicant and the victim had already married and they have a child also. The marriage was performed according to local rituals. Fair. We have considered the submissions made by the learned counsels on both sides. We have also gone through the impunity judgment. Fair. Having heard the learned counsels on both sides, it is hereby directed that the judgment or the sentence imposed upon the applicant on 18/12/2023 by the learned special judge POXO West Coming District in POXO case number 04 of 2022 shall remain suspended in the disposal of the applicant. The applicant Pema Razangju shall be released on bail of rupees 25,000 with surety of like amount with the satisfaction of the learned special judge POXO West Coming District. The highest and disposal of it.
DPO.
Main. Or in the main appeal. In the main appeal, or Mr. R. Sonar appealing for lawyer's name saying. Lawyer's name saying. This appeal after 4 weeks for hearing.
Developers.
I love it.
Yes. May I please lawsuit?
My lord, I think learned senior counsel, Mr. Appam, is stuck in traffic. That's why he is cannot to reach court at time, my lord. There is heavy traffic at Borum. Yes, please, my lord. My lord,
Some other day because we have single bench also.
next week, my lord, then.
After 2 weeks.
2 weeks.
Who is for the appellant?
Learned senior counsel. Yes.
Or what is your name?
My name is H. Lampu.
H. Lampu.
Yes, ma'am.
You are for the respondent.
Oh, yes, ma'am. I'm for the respondent.
The learned counsel, Mr. H. Lampu, appearing for the respondent. You are for the respondent.
Yes, ma'am.
Has submitted that the learned senior counsel Mr. A. Apang, who is representing the appellant, has not yet come to the court today. Considering the submission made by the learned counsel, the hearing is adjourned today, list after 2 weeks for hearing.
My lord, fixed date may be given after
What was the date?
Yes, ma'am.
Then you suggest one date,
Yes, ma'am.
after 2 weeks.
Weeks. My lord, that will be on
Today, what is the date?
today is my lord
19.
19. That will be on 7th of my lord, April.
7th April,
Yes, ma'am.
7th, list on 7th April for hearing.
Obliged.
Okay. Yes.
Please, your lordship. May I seek lordship's indulgence, my lord, to move to criminal petitions unlisted, my lord. The section relates to 528 of BNSS, my lord, corresponding to 482 CRPC, my lord. The fact remains, my lord, yesterday I came from Guwahati and my local council was preparing. Some discrepancies were detected, my lord. Now this morning is filed. Of course, subject to lordship's convenience.
Criminal petition.
Criminal.
Tomorrow I'll take it.
The fact remains, my lord. This evening I am leaving for Guwahati, my lord. This evening I am leaving for Guwahati, my lord. I will stay in Guwahati.
No, today I have some meetings also. I have not have time.
In that case,
Tomorrow.
Lordship, I beg to mention item number 24 and 25, Lordship. I on behalf of I. Ahmad, Lordship. And this matter may be fixed for Lordship 24 April, Lordship 2025, Lordship.
7 April.
Yes, Lordship. Counsel is from out of his station, Lordship.
What is your name?
H.T. Tara, Lordship.
The learned counsel of H.T. Tara, appearing for the appellant prays for an adjournment on personal grounds. Heard, amicus is also there. On the basis of the request made by the learned counsel, the matter is adjourned today, list on 7th of April for hearing. For hearing.
My lord, I am the appellant in 24. So my lord, I am required seeking for specific date. See that
Maybe fixed for 24 April, Lordship.
24 April.
Yes, Lordship. My counsel is from out of his station, Lordship. So
Modi is also there.
my humble praise that. Lord.
Modi's name is also there.
yes, I am in 24, my.
Huh?
24.
You are 24.
Yes.
Or you are in 25.
Both, Lordship.
Yeah.
24 and 25, Lordship. Oh, so sorry, Lordship. So sorry, Lordship. Take that. Okay. 24. Sorry, Lordship. 26 and 27, Lordship.
26 and 27.
Yes, Lordship. Yes, Lordship.
Parme is also there. Have you informed him?
Okay. Yes, Lordship.
Heard Mr. H.T. Tara, appearing for the appellant. Heard Mr. L. Parme, the learned counsel appearing for the respondent. On the request of Mr. Tara, the hearing is adjourned today. When do you want it?
24, Lordship. 24 April, Lordship.
List on 24 April for hearing.
Yes.
Okay.
24, Lordship.
Along with item number 27. Yes.
lordship, item number 19. I'm on behalf of the petitioner, counsel for the petitioner, T. Taba. The matter may be listed after 3 weeks. He wishes to file an additional affidavit. And also there is an interim order that may continue.
You want to file additional affidavit?
Yes, Your Honor.
What is your name?
VT Gurung.
The learned counsel, Mr. So-and-so. Appearing on behalf of Mr. T. Taba,
Yes, Your Lord.
prays for some time to file an additional affidavit. His prayer is allowed. When do you want it?
Interim, 3 weeks, Your Honor.
Least after 3 weeks? Is there any interim order?
Yes, Your Lordship.
The interim order past trial shall continue until then.
Oblige, Your Honor.
My Lordship,
Yes.
I beg to mention item number 7, Lordship, on behalf of J. Genie, Lordship, petitioner.
Item number 7.
Item number 7, yes. This matter may be listed after 3 weeks, Your Lordship. Herein, we are supposed to file affidavit in reply, Your Lordship. It is, we will file within this week, Your Lordship.
Okay.
Matter may be listed after 3 weeks.
Affidavit in reply.
Yes, Your Lordship.
What is your name?
T. Tarin,
Johnson so and so. Appearing for the petitioner praised for an adjournment. Have you informed the other side?
yes, Your Lordship.
Praised for an adjournment and also submits that he has already informed the other side. The prayer for adjournment is allowed. Least after
3 weeks, Your Lordship.
3 weeks. Before the next date of listing, the affidavit in reply shall be filed by the petitioner.
Yes. Oblige, Lordship.
May I sign, my lord?
Yes.
And item number 25, my lord.
25.
25.
25 is with 24.
Yes, my lord. 25 today I have filed my authority, my lord. And my 25, my lord, my plea, my lord, will be not on merit, my lord. Basically, my plea will be on probation of offender act, my lord. So I pray, my lord, this case can be split, my lord. And
No, you were the appellant,
I am the appellant in 25, my lord.
25.
25, my lord.
Now what do you want?
My lord, I'm not challenging the judgment on the merit, my lord. My submission will be limited in under section 360 of CRPC in the probation of offender act.
Personal offender.
So in such view, my lord, if petitioner counsel in the 24, my lord, want to argue the matter, my lord, let them, my lord, and my case may be split today, my lord. Yes, today only I have filed my Okolatnama, my lord.
I have no objection, Mark. Even if the border is because in my case, in the item number 24, my lord, the punishment is 10 years.
Yes.
And in case of the 25, the punishment is 6 months only. So there is certain differences. Both the case has been fixed together only on the mere ground that they belong to the same
incident,
incident.
trial.
But distinctly, there is differences in the punishment. So I have no objection for splitting, ma'am.
You write the order in item number 25. The learned counsel, Mr. L. Parme, appearing for the appellant, submits that the criminal appeal number 32 of 2022 is listed along with the present appeal. Stop. Mr. Parme submits that he is not challenging the judgment part of the impugned judgment. Rather, he will be pressing for releasing the appellant on probation of Offenders Act. Therefore, Mr. Parme submits that this appeal should be separately heard from criminal appeal number 32 of 2022. Fair. The learned counsel, Mr. C. Moody, appealing for the appellant in criminal appeal number 32 of 22, has submitted that he has no objection if the criminal appeal number 30 of 2022 is heard separately. Fair. I have also heard Mr. T. Atte, the learned additional public prosecutor for the state of Assam. The present appeal, being criminal appeal number 30 of 2022, shall be listed separately. When do you want it?
After 3 weeks, my lord.
After 3 weeks. Okay.
Obligation.
Oblige, your lordship.
Number 1.
My lord, this is bail application, my lord. Earlier, the petitioner, my lord, he's moved bail twice, my lord, before the special court, my lord. Special judge, and it was rejected, my lord. My lord, may kindly come to page number 50. This is the FIR, my lord.
Is it a POXO case?
Yes, my lord.
Then the informant has to be heard.
My lord.
I will issue notice to the informant. Heard Mr. D. Kamduk, appearing for the petitioner. Heard Mr. D. Louis. The learned public prosecutor for the state of Arunachal Pradesh. Issue notice. No formal notice is required to be sent to the respondent number one, as because Mr. Louis has accepted notice. Extra copy of the petition shall be provided to him. The applicant, the petitioner shall take steps for service of notice upon the respondent number two through the office of the public prosecutor. When it will come back
My lord, may this, the matter next week, my lord.
next week? You
Yes.
suggest on date.
My lord, yes. My lord, can it be taken up 27, my lord? No, I'm sorry, my lord. My lord, may I kindly fix the matter on first of. Oh, no, again, first. Allow me. Can it be fixed on 24, my lord? 24?
24.
That is.
It will come or not? What is the problem?
Then, my lord, may fix the matter on 7, my lord.
7th April.
Yes, my lord.
Do this matter on 7th April.
Much obliged.
You are for a petitioner.
May I please, Lordship? Lordship, this is a criminal petition for the passing of the criminal proceeding on the basis of the mutual settlement between the parties, Lordship.
Where is the FIR?
Lordship, may kindly come to page number 16, Lordship. This is the type copy of the FIR. Lordship, may I read the FIR? Lordship, I would like to inform you that this afternoon on the 17th day of November, time around 12:40 p.m. at Ma Malini Hotel, Likhavali, one Sri Nyabam Tasar assaulted me for no reason. Therefore, I request you to kindly register a case under relevant section of IPC for my kind justification, Lordship. This was the FIR, Lordship.
Why he wants, he has compromised.
Yes, Lordship. Lordship, on the basis of mutual settlement, Lordship, which is on page number 33, Lordship. This is the copy of the agreement, Lordship. Lordship, this is a very old case of 2010, Lordship.
2010.
Yes, Lordship.
Very old case.
Lordship, the case is pending in the stage of framing of charge, Lordship. Still.
Charge sheet file.
Charge sheet file, Lordship.
Where the case is pending now?
Lordship, Pasigat, Chief Judicial Magistrate, Pasigat, ECM district.
GR number 18. Case number is GR 18.
Lordship. Lordship, case number is Likhavali PS case number 25/2010.
There is the police case. After filing of the charge sheet.
Yes,
that is
their number is 18/25, Lordship.
pending before the court of Chief Judicial Magistrate. Okay. Ajay, what do you want to say?
Lordship, this is compoundable.
Huh?
323 is compoundable, Lordship.
No, Lordship, charge sheet was filed under 341 and 326. The FIR was
341 and 326.
Lordship, then it, as per Lordship, the injury is grievous, but they have Lordship mutually settled the dispute, Lordship, then it can be Lordship.
It is first.
Report.
Lordship.
Yes, ma'am.
Yes.
Here I have very limited clear, my lord, only for direction, my lord, to dispose of my representation, my lord, on that I submitted on my lord 10/3/2025, my lord.
Your representation,
Pardon, my lord.
your representation.
Yes, my lord, I have submitted representation dated 10/3/2025, my lord. I am playing only direction to the respondent to dispose of my lord. That. What happened in this case, my lord? I participated in a tender, my lord. Now tender board, my lord, declare I am the L1, my lord. Now tender board declare that I am abnormally low, my lord. Now in such situation, my lord, the rule applicable, my lord, that is for procurement of goods, my lord, manual 2017, my lord, mandate that I may be issue a written notice, my lord, to satisfy whether I can supply those material on my quoted amount or not. That is a mandate, my lord. Therefore, I have submitted representation to the authority, my lord. My only today my humble submission would be, my lord, let the respondent, my lord, be directed to dispose of my representation, my lord, without touching the merit, my lord.
That can be done.
Or Mr. L. Parman, preparing for the petitioner. Or the learned petitioner of the general, Mr. So-and-so, preparing for the respondents 1 to 5.
1 to 5.
Representation, my lord, will find it page number 43, my lord, annex number 7, my lord.
43. Your
Right.
tender was rejected.
Not rejected, my lord. I was declared L1, my lord, but L2 has been recommended for the award of work, my lord.
Okay.
I was the L1. I was declared L1, my lord, but they declared that I'm abnormally low, my lord. My quoted amount is, my lord.
This is an application under Article 256 of the Constitution of India. Where is the order?
Recommendation, my lord, will buy at page number, my lord.
Whereby the L2 was given.
That, my lord, will find at page number 32, start from 31, my lord, 32, my lord.
32.
32 recommendation is there, my lord.
It starts from 31.
Start from 31, my lord. Recommendation, my lord, will is second last fire, my lord, 32, my lord.
Application under Article 226 of the Constitution of India, challenging the recommendation
Recommendation dated is 4/3/2010,
dated 4/3
2023, my lord.
25.
2000
Or 25, 25, my lord.
25.
At page number 30, my lord, at second. 4/3.
Giving the contract to work to L2.
L2, my lord.
Yeah. The director of biological park, Ganga, biological park, comma, the director, comma, biological park, comma, Ganga, comma, Itanagar, invited tenders through the notification number GBP-18/25 2025 /1473-77 on 14. Is it 01?
14-2.
14/2, my lord.
14/02.
02 to 10.
2025. The present petitioner filed his tender and he was ultimately he procured the L1 position. In spite of that, the other tenderer L2 was given the works.
Recommended, my lord, not, he had not
Uh,
given,
uh,
recommended.
L2 was recommended by the committee. The petitioner filed a representation on 10/03/2025 before the Director of Biological Park, Itanagar, come the chairman, tender board of the NIT number DBP stroke 18 stroke 2025 stroke 1473 dash 77 dated 14 February 2025. Where Mr. Parme submits that his representation is not yet disposed of. Therefore, he prayed for a direction, asking the respondents 1 to 5 to dispose of his representation within a fixed time limit. The learned Advocate General has submitted that if the court passes such an order, he has no objection. Fair. Accordingly, the Director, Biological Park, Itanagar, come Chairman, Tender Board of the NIT shall dispose of the representation made by the present petitioner within 1 month.
No, my lord, 1 week, my lord. Next, 1 week in the sense, by
Yes,
April,
1
my
week.
lord, what would be started?
1 week,
Yes, my lord.
within next 1 week of receiving this order.
Yes.
The writ petition shall dispose of accordingly.
Yes, my lord.
High level.
Yes.
Your Lordship, this writ petition is filed in regards to the anomalies practiced during the execution of the Kempa project under Shergao Forest Division, Your Honor. Having suspicion of the anomalies conducted, I have filed RTI on 27/12/2021, and in that response, Your Honor may please come to Annexure 11, page number 269, Your Honor. Here, Your Honor, State Information Commission has clearly stated that they have not published any NIT notice inviting tenders in the newspaper, Your Honor. So it was done flouting all the rules and regulation of the CPWD manuals and GRF rules, Your Honor.
Mr. Nabam is appearing for all. 1 to 4. Yeah. 4, 5. Then 6 is Principal Secretary. Department of Home. And 5, 6. 6 is Central Business Commission. For 7. Central Vigilance Commission. Yes. I will issue notice today. Heard the learned counsel, Mr.
P. Wangpan, Your Lordship.
Appearing for the petitioner. Heard the learned additional Advocate General, Mr. R.H. Nabam, appearing for the respondents 1 to 4 and 6. 1 to 4 and 6. Heard, Mr. What is your name? Appearing for the respondent number 5. Issue notice. No formal notice is required to be sent to the respondents 1 to 6. As because the learned counsel is representing them, have accepted notice. Extra copy of the petition shall be given to them. The petitioner shall take steps for service of notice upon the respondent number 7 by registered postal area. List after 4 weeks.
Most open.
Number 5.
May I please, Lordship? Lordship, petitioner herein is impugning the NIT issued by the executive engineer PWD Hireling Division, Anjar. Lordship may find the NIT, impugn NIT at phase number 31.
This is the NIT.
Phase number 31, Lordship.
Okay, all right then.
Lordship, Lordship may kindly see the bottom of the same NIT, Lordship. Where it is, Lordship. Lordship, here it is written that other details may be seen in the notice inviting tender, inviting for bid number so and so, uploaded in the PWD website www.arunachalpwd.org. Lordship, after that, Lordship issuing this notification, NIT, Lordship, the petitioner herein have checked the website of the department, Lordship. But nowhere in the website it is uploaded. And even, Lordship, the NIT has not been published in the paper, Lordship. For that, the petitioner has applied for the RTI, Lordship. Lordship may find the RTI on phase number 51, Lordship.
Page number?
51, Lordship. Page number 53 is the RTI application, Lordship. And reply is at page number 56, Lordship. Reply at page number 56, Lordship.
Notice not published in the newspaper.
No, Lordship. Not published in newspaper, even not uploaded in the department website as prescribed in the NIT.
Even in the website, it is not there.
No, Lordship may find the latest website check on page number 34, Lordship. Page number 35 is the NIT uploaded by the department. But
35.
35, Lordship. This is the NIT uploaded by the department of different tender, Lordship. But here, the same NIT has not been uploaded. 35 and 36. This is the latest update till filing, before filing of this instant application. So, Lordship, while doing so, the respondent authorities have grossly violated the provisions of CPWD manual. Lordship, CPWD manual, Lordship may find the CPWD manual at phase number 51. Lordship.
Yes.
51 4.13,
1.13.
Lordship. Even, Lordship, the NIT was issued on 10th of this month, Lordship. And that NIT amount, the estimated cost is of rupees 19 crore, Lordship.
No, where did you get the NIT? It is not published in the website nor in the newspaper.
Yes, Lordship.
From where did you get the NIT?
Lordship, I have applied RTI to the Department of Director of Information Public Relations, Lordship.
Okay.
This is the competent authority to publish the NIT.
Hmm.
Before issuing NIT, the department has to requisition the department for publication of the NIT in the local dailies. Lordship.
Hmm.
And even in their NIT itself, it is written that the same will be uploaded in the department website, Lordship, but that has not been complied with. Lordship.
In 3/2025.
Yes, Lordship. And however, Lordship, the respondent authorities, they are going ahead with the tender process, Lordship. Now on 17, they have opened the tender.
Hmm. On 17, they have opened the tender.
Yes, they have opened it, but it is yet to be awarded, Lordship.
Yes, what do you want to say?
Since also they have very much on this one. Also, this it's not that we have any advice in this case. Plus, the part is on brothers, this is just individual proposal incentives and development promotional amendment act. This is an amount of 8 crore NIT also. And this is within
Oh. Yes.
this is
Above 8 crore.
among the domicile, yes, within
All-
the district also. And it is not from this district also.
It's all registered contractors in class 1 categories,
Yes, domicile,
domiciled within the territorial jurisdiction of the district.
yes, jurisdiction is the same district also. And
Oh.
this is under district and this petitioner is from Lower Development. It's a different district.
Oh.
This is first extent also, and then also where we have said that the time limit for the manual is 14 days. Also in I could not corporate now, but then we were about to say because the item is coming to the. In two. There is a provision in case of agency also. In 3 days also, in 10 days also, in 7 days also. The NIT can be. Time can be given. Time can be given. Limited time can be given. So, logic. This is within the district logic. Since it's not from this district logic, without going through the merit of the case logic. The petitioner may not be entertained.
Lordship may come to the phase number 28 of the petition, Lordship.
Yes.
Lordship, this is the authorization. In fact, Lordship, the farm is from the lower Dibang Valley. However, the petitioner number 1 is the proprietor of the farm, and petitioner number 2 is the authorized person who is belongs from the Anjao district. He belongs from Anjao district, Lordship. So then the question of locus doesn't arise, Lordship, as pointed out by the learned.
Who is the registered contractor? It is farm.
A registered contractor is petitioner number 1, Lordship, and petitioner number 1 has authorized the petitioner number 2 to obtain the tender, to procure the tender, to participate the tender in the said NIT, Lordship.
But petitioner number 1 is the contractor.
No, Lordship, petitioner number is the owner of the farm. He's the sole, he's the proprietor And the petitioner number 2 has obtained the power of attorney.
No, if he files a tender.
Yes, Lordship.
He will be filing the tender in the name of petitioner number 1.
No, Lordship, tender would be filed by only by the petitioner number 2, Lordship. He has obtained the power of attorney from the petitioner number 2, Lordship, 1, Lordship.
Farm is a different thing.
Yes.
Lordship, in Anjao district, there is no class 1 contract of farm, Lordship. Yes, Lordship, that will come up during the course of hearing, Lordship. So in this state, even Lordship, I am not taking this as the ground. Lordship, what I am taking the ground is that the NIT has not published as mandated under CPTW Manual 2019, Lordship. And even the NIT, the issuing authority has clearly stated that the same would be uploaded in the website.
Petitioner number 2 is the power of attorney holder.
Yes, Lordship.
It's the same thing. Petitioner number 1 is the main contractor.
No, Lordship, the petitioner number 2 has obtained the power of procured the power of attorney from the petitioner number 2. Now, Lordship, if allowed, the petitioner number 2 is going to participate in that NIT, Lordship.
Petitioner number 2 will be participating in the process.
Yes, Lordship.
In the name of petitioner number 1.
Lordship.
So petitioner number 1 is from Lower Dibang Valley. So he is not domiciled here.
Lordship, in that
According
case,
to this rule, this is a government rule.
Lordship, for that, there is no any registered contractor of class 1 within the district of Anjao, Lordship. What happened in this act, Lordship? If there is no farm available within the district, then nearest district, the farm of nearest district can participate. This is the criteria, Lordship.
It's not the case here.
Yes, Lordship.
Let them say.
Okay, now
There is no.
at this stage, I will give her some time to file an objection or reply, but no stay order will be granted.
At least, Lordship, they are going with the tender process, Lordship, and they have opened the tender on 17th of this.
There are some defects in your case. That is why you are not getting any interim order.
Lordship, I am the power of attorney holder, Lordship. I have duly authorized by the proprietor of.
But the original man is from Dibang Valley, not from Anja, from Dibang Valley. So everything will be done by the Dibang Valley farm.
Yes, Lordship, my sole contention is that the NIT should have been published, widely published in the local papers, as well as the NIT should have been uploaded in the website as prescribed in NIT itself, Lordship, by the issuing authority. But that these two conditions has not fulfilled by the issuing authority. Thereby they have violated their own conditions, terms and conditions, Lordship. But they are going ahead with the illegalities. No, tender has already been opened. Tender has been already opened. After opening of tender, what's the purpose of public?
You have to wait.
That will not sustain, Lordship. Before issuing the tender, it should have been published, Lordship.
Yeah.
This is my contention, Lordship.
Your locus is a matter of debate. That is why. Heard Mr. R. Ingo appearing for the petitioners. Heard a learned senior government advocate. Additional senior government advocate, MS so and so, appearing for the respondents. This writ petition has been filed on the ground that the notice inviting tender was neither published in a newspaper nor it was uploaded in the website of the PWD. Therefore, the petitioner could not file his tender. The learned counsel for the petitioner submits that according to the CPWD rules, the said act of the respondents is bad in law. The learned counsel MS so and so has relied upon the Arunachal Pradesh district-based entrepreneurs and professionals, bracket start, incentives, comma, development and promotional, bracket closed, again bracket start, amendment, bracket closed, Act of 2020 and submitted that the petitioner has no locus standi to file this writ petition. The learned counsel has pointed out that according to the said rule, for contracts above 8 crore and below 20 crore, comma, all registered contractors in class 1 categories domiciled within the territorial jurisdiction of the district are entitled to take part in the process of filing tender. The learned counsel has submitted that the petitioner belongs to Lower Dibang Valley, whereas the tender was made, or NIT was issued in the district of Anjao. Having considered the submissions made by the learned counsels of both sides, the respondents are directed to file the affidavit in opposition. After receipt of the affidavit in opposition, the prayer for any interim order shall be considered.
Lordship, at least this stage, the status quo may be, Lordship. Otherwise, they will award the, then this petition would become infructuous, Lordship.
According to the rule, you have no locus standi, so let them file the affidavit in opposition.
At least till the returnable that Lordship, at least the work order may not be issued.
No.
At least Lordship, Lordship, there is clear violation of their own terms and conditions by the NIT issuing authority. Lordship,
There is another violation of this rule. She has shown. There is a.
Lordship, as of now, there is no any class 1 contractor in the district. I am submitting on affidavit, Lordship, before this honorable court.
What is the different, but for that matter, there is no rule that from the neighboring districts, some people, class 1 contractor can file the tender. There is no such rule. There is a problem. Let them file at least after 3 weeks.
At least, Lordship, status quo may be, Lordship.
So,
Then, Lordship, 2 weeks, Lordship.
at least after 2 weeks. Yes.
My lord, this is a violation of, my lord, Arunachal Pradesh Public Premises Eviction, Unauthorized Eviction of Occupant Act, purportedly done by the, my lord, Deputy Commissioner.
Unauthorized occupants act.
Yes, my lord. So, my lord, the Deputy Commissioner who is not authorized to issue such notice or order, my lord. My lord, kindly page annexer, my lord, annexer 5, page 69, my lord. This is issued by the Deputy Commissioner, who is an appellate authority in the public premises.
Page number 69.
69, my lord. Dated 2nd January 2025, whereas a report has been received from the Director of Health Services, Naharlagun, by number this dated authority to the effect that a OBT building has been constructed within the State Cancer Institute site at Mitru village by the disruption of construction work at the site. Whereas the circle officer Doimuk has been directed to verify in the field and submit report. Whereas as per the verification report of the circle officer Doimu, Shri Divya Tana, this is petitioner, has constructed OVT house within the Cancer Institute. Therefore, Divya Tana is hereby directed to show as to why and what without the authorization land document in his favor constructed the OVT building within the State Cancer Institute at Mitpu, and the illegal structure should not be evicted. The so-called notice reply should reach the undersigned on 6 January 2025 at 11 hours without fail. So, my lord, this is totally illegal. He, Deputy Commissioner cannot issue such a notice, so-called notice, my lord. Number one.
Who issues actually, who is authorized?
State officer, state of state officer, the authority. So, my lord, in person to that so-called notice, my lord, the petitioner has submitted an application that is annexure 6, page 70, my lord. My lord, here, my lord, he has prayed for the grant of 7 days time to satisfy the reply to so-called notice dated 02/01/2000 issued by your esteemed office. With due respect and humble submission, I would like to appraise your esteemed office and prayed for necessary consideration. I was but out of station, sorry. I was out of station from last 31st December 2024 to 5th January 2025 to stay with parent during weekend, and yesterday evening on 5/01/2005, I came down from native place to Nirjuli resident, in which I find a so-called notice sent through WhatsApp bearing to my old SIM card, but said contact number is being used by domestic helper at Nirjuli resident, and it was not communicated to me on time. Right after getting the so-called notice issued from your esteemed office, I personally appeared to seek a time to file satisfactory reply. So he wanted to take time, that is. So thereafter, my lord, again another so-called notice was issued by the Deputy Commissioner, that's annexure 7, page 71, my lord.
71. So, what happened to your representation?
My lord, representations all are pending, my lord. All are pending, my lord. So, my lord, I have to pertinent to mention hearing that, my lord, in a similarly situated cases, my lord, they have already issued LPC, my lord, annexure 4 series, my lord. My lord, I want to back it to that. My lord, I have purchased the land, and now in my possession, that land annexure 3, my lord, 31, my lord. I purchased the land from
No,
3 persons.
Your representation is still pending.
Pending, my lord. So, my lord, these are the, my lord.
Let the Deputy Commissioner dispose of this representation first.
No, yes.
What's page 71 again? Page 71.
Yes.
This is the order of the Deputy Commissioner. This was set aside by which the next page 72. Obviously, 5/25/2025.
The same petitioner.
Okay.
Yes.
This order is 71, page 71 order of the district was set aside by this honorable court.
Oh, sorry.
By this honorable court, Lordship, kindly, Lordship, see the para 5, Lordship. Para 5, page 72.
Yes, considering the submission.
Yes.
And matter
Also,
disposal.
it's remitting the matter to the Deputy Commissioner with the direction to take necessary and appropriate steps in accordance with law. Accordingly, Lordship,
Oh.
page 80.
80.
Page 80. So, but is issued by the estate officer, Lordship.
Oh. Oh, yes.
Because Deputy Commissioner is the appellate authority, he could not have issued the, that's why it was set aside, and then lordship.
State officer.
Estate officer issued
They-
following the process of law.
Same matter.
So, to this so-called notice, they have given lordship, already they have written reply to the so-called notice. Process is on. Actually, not the petitioner is lordship asking for, I'm not getting.
Yes, my lord. Exactly, my learned friend has rightly pointed out. Annexure 10, page 80. Is finally SDO come, state officer has issued this so-called notice under section 4 of the Public Premises Act. So in person to this, my lord, the petitioner has submitted the reply, my lord, annexure 11, my lord. 11, page 82. So the so-called reply filed by the petitioner is still pending, my lord. No any action has been taken. So thereafter, my lord, the petitioner has moved the appeal before the deputy commissioner. That's the annexure 12, my lord. Page 86. So these all sequence of the events are still pending, my lord. No any action has been taken.
There is no decision.
Yes.
So my lord, only my prayer before lordship said, let the matter, my appeal be disposed of, and till such time, my lord, my land in occupation by the petitioner should not be disturbed, my lord.
That kind of order cannot be given.
My
Because
lord?
the matter is already pending. Your appeal is pending.
Yes, my lord.
Your representation before
But
the
till-
state officer is also pending.
Till pending, my lord, pendency of that period, my lord, I should not be disturbed, my lord. Only prayer that.
No, that kind of order cannot be given.
My lord, because similarly situated, my lord, places, my lord, they have already issued the LPC, my lord. My land is also from the same area, my lord.
Let your representation be, or your appeal be disposed of first. I can ask them to dispose of the appeal within a short time. After that, you come again.
And my lord, there is no any land allotment from the respondent number 1, 2, 3, my lord. That is your health department. They have no any such, my lord, authority, my lord. We have no any problem, my lord, for construction of your, my lord, your cancer institute. But subject to condition that they should obtain the land allotment first. If they can take the action against us, why not the government, they should properly obtain the certificate. It's not here.
What's if there is any decision against the petitioner from the estate officer, then only he can appeal to the deputy commissioner.
I have already
See-
filed my lord. I have filed already reply. They have not filed.
Without any decision of the state officer, you filed an appeal.
No,
That
see,
is
there
not possible, my lord.
Pending my lord, till today, my lord.
There is no order of the estate officer only. And then without any, this one lordship, he have filed appeal under section 12.
This court will ask the state officer to dispose of the.
Lordship, this process is on, lordship will
This is
see the
going on.
date also. He have replied.
There is
the-
no, my lord, there is no evidence for that the process is going on. How the, my lord, the learned friends are submitting such a wrong submission before the court, my lord? Where is the evidence?
This is
There is no any evidence that they are doing this process.
You filed the affidavit.
Till then, my lord, I may be protected. My lord, I may be protected, my lord.
Mr. T on appeal for the petitioner. Have the learned senior additional government advocate. MS so and so appeal for the.
I'm for respond number 3, 2 and 3, my lord.
You are for one.
For health department, standing council health department, respond number 2 and 3, my lord.
Now, who is for one?
One is
Lordship,
for my.
I'll be,
DC, my lord.
no,
DC, 4 is DC.
one,
One.
lordship,
Appeal for
one,
response one.
4, 5 and 6, lordship.
1, 4, 5 and 6.
Yes, lordship.
Heard Mr. So and so appeal for the respondents 2,
3, my lord, I'm appearing. 2 and 3.
2 and 3. So it is complete.
Yes, my lord, completed.
Who is for 7?
7 is, my lord,
It's a private respondent.
private respondent, my lord. He is a contactor.
Issue notice. No formal notice is required to be sent to the respondents 1 to 6. As they are represented by the learned councils. The learned council, Mr. So-and-so and Mr. So-and-so, has accepted notice on their behalf. Extra copy of the petition shall be provided to them. The petitioner shall take steps for service of notice upon the respondent number 7 by registered post with AE. List after 3 weeks.
My case may be considered after X month.
The prayer for any interim order shall be considered after the next fixed date.
Much obliged. My place, my lord.
Yes.
My lord, this is the matter out of the land dispute. So far, my lord, the exchange of pleading is concerned, my lord, the exchange of pleading completed on 7 February 2024. Thereafter, this matter has been keeping pending and adjourned. So at the outset, I am praying for dispose of this matter.
Now, it will need a little bit of hearing.
My lord,
It will require a little bit of hearing. So I will hear it on some other day.
my lord.
Heard Mr. C. Modi appearing for the petitioner. Heard Mr.
Thank you for all the respondents.
Appearing for the respondents.
Yes, 1 and 2.
You have filed affidavit in opposition.
Yes,
So the pleadings are complete. When do you want it for hearing?
after the break now.
After?
After vacation.
Hmm?
After vacation.
After vacation, yeah. Leave this matter for hearing after the ensuing vacation. What vacation is coming? Summer vacation.
Summer vacation. Yes.
Huh?
Be
BU vacation. After the ensuing BU vacation. How long is the BU vacation here? Huh?
A week time goes.
Huh? 1 week. Long vacation. Okay.
Oh,
Obliged.
Item number 9.
May I please,
Yes.
my lord, this is a criminal petition, my lord, for quashing of the FIR, my lord, and the charge sheet, my lord. My lord, here is the case, my lord. From the FIR itself, my lord, before coming to the records, my lord, I'll just tell the brief of the, my lord, contents of the FIR. What the, my lord, the complainant is saying is that, my lord, that we have been in relationship for more than 7 years, living as a husband and wife. And I even went and I met the first wife of the petitioner. She had no objection. We continued relationship.
Okay, notice upon respondent number 2 served or not?
Sir, I think last occasion also, many times he appeared also, my lord.
Who is appearing for respondent number 2?
Private counsel appeared earlier on many occasions.
Lordship, the concept for the respondent informed me that he was out of town.
Out of town.
Yes, Lordship. Will be taken few days.
For respondent number 2.
Yes. For the concept for the informant, Lordship.
Next Tuesday,
My lord,
Monday, there are some other cases.
my lord, one day, they out of station. Then, my lord, it can be after Bihu, then, my lord, I will be out of station.
Heard Mr. R. Soni appearing for the petitioner. Mr. D. Louis, the learned public prosecutor, has submitted that the counsel who is representing the respondent number 2 is out of station. Fair. Considering the submission made by Mr. Louis, the matter is adjourned today. You want a date?
My lord, least after 3 weeks, no issue.
List after the ensuing BU vacation.
Bye. Much.
May I
Yes.
please lord. My lord, this is a joint petition, my lord, filed by the complainant and the accused person, my lord, for quashing of a fire, my lord.
Is it a
Right.
joint petition?
Yes, my lord, joint petition, my lord, filed by the complainant and accused upon compromise of their dispute, my lord. My lord, the FIR is at phase 11.
Okay, Hage, what do you want to say?
Lordship, CD has arrived, Lordship. Lordship, minor issue, Lordship, they have, or although they have mutually settled the dispute, Lordship. Here, Lordship, the MB, in the case, there is, Lordship, the MBA report is, yet to receive, Lordship.
My lord, on
Only
my
this much, Lordship.
Simple case of accident.
yes, my lord, accident, my lord. My car has been damaged, my lord, because of the accident. That's why I filed a FIR, my lord.
Your car was a Maruti 800.
Maruti 800, my lord. That has been hit by the, my lord, the 10-wheeler fuel tanker of the, accused
The vehicle which hit your car was a truck
truck, my lord, fuel tanker.
Huh?
Fuel tanker.
or fuel tank.
Yes, my lord. My lord, accident is just hit my
Okay,
car.
this cost.
My lord. Obliged, deeply obliged.
My lord, may I please submit? My lord, the council has just, this petition applicant council. My lord, they've telephonically requested me to pass over the matter for some time. There's a huge traffic jam. Item number 11 and 12. Maybe last item.
Okay, all right.
Obliged, my lord.
Okay. Great crime. 11 to
May I please?
Yes.
My lord, this is a pre-arrest bail application, my lord, in connection with Naharlagun Police Case number 20 of 2025, my lord, under section 466, 468.
The FIR is page number 21.
My lord, FIR is page number 18, my lord, starts from page number 18.
18. It starts from 18.
Page number 18, my lord, 21 is the, my lord, main content, my lord. Well, basically, my lord, what he is saying, my lord, that,
Okay, Mr. Suma, please read the FIR first.
yes, my lord. FIR against Mr. Robin Bulkarshiya so-and-so. Respectfully begs to inform you that on 7th day of October, I went to the Office of Director Civil Supply, Government of Arunachal Naharlagun to pursue and to get release my HTS bill, which was submitted to the department in the year 2010. During my visit, I came to learn that one Robin Bukal Saria, son of so-and-so, Naharkatia town, Assam, in connivance with Jai Kishan Sarma, son so-and-so, were fraudulently obtained power of attorney as well as deed of agreement, which was alleged to have been executed on 25 January 2011 in between Sri Tai Tayu, son of Tai Sakab, and Mr. Robin Bakuseria, so-and-so, and also deed of agreement dated, which was alleged to have been executed in between Tai Tayu, so-and-so, so-and-so. So therefore, joint application of Kambang MPCA chairman and Sri Robin were submitted to the Director of Food and Supply Naharlagun also. In the said application, they requested to release the payment of HTS bill. Enclosed herewith copy of power of attorney dated, deed of agreement dated, joint application dated so-and-so. That after perusal of the power of attorney, deed of agreement and joint application which was submitted to the Director of Food and Supply, Naharlagun, and found that in all the three documents, Mr. Robin Bokursia, in connivance with Jai Kishan and so, has forged my signature and fraudulently obtained the power of attorney and deed of agreement. In further inquiry, it also learned that the witnesses reflected in the said documents were not present in the front of Notary Dibrugarh. Enclosed copy of affidavit shown by Sri so and so, whom it was cited as second party in the agreement. That, sir, it is crystal clear that Robin Bakuseria, in connivance with Jai Kishan Sharma and Ashok Kure, forged my signature to commit fraud by submitting the said documents in the office of Director of Food Civil Supply so and so. Therefore, I do highly request you to kindly register a criminal case against Robin Bakuseria, Jai Kishan Sharma, and Ashok Kumar Tiwari under so and so and so. My lord will see here. This FIR, my lord, alleging, my lord, that I have forged 3 documents. It's completely false FIR. I am coming to the fact, my lord. If something happened, my lord, I am a resident of Naharkatia, Assam. I'm very well settled. I have my children who are some are doctors, all this thing. I am a businessman. Nothing, no criminal antecedent. This person, my lord, the informant, he is a, my lord, proprietor of one a Kambang MPPS chairman. So what happened, my lord, in the year 2010, that time, my lord. So he got for supply of this food grains for the district of Tirap Khunsa, that Tirap area, my lord, near Naharkatia area. So he approached me saying that I am not in, since I do stay here, I am not unable to execute the work, so that you take my power of attorney, agreement entered, my lord, and whereby it was agreed that 33% of the bill amount I will be entitled for it. Then 2010 work was executed, my lord. Bill was submitted, my lord. Payment, all this year, no payment happened, my lord. Then recently when payment was supposed to be released, my lord, this person, he again come to me saying that you reduce this your share from 30% to below, which I flatly denied, my lord, because this is in the agreement, my lord, I have enclosed here, that 30% is my share. Thereafter, now, what is his intention is completely, my lord. Now that he doesn't want me to take the share in the bill, my lord. Though the work I have executed. Now, my lord, what happened? This honorable court has granted me interim order. Immediately, I appeared for twice, my lord. I have submitted the entire original document of 3D document, attorney agreement, and the bill which I submitted, my lord. So, my lord, this is nature of the case. All the offense below, my lord, 7 years, my lord. Custodial interrogation is, my lord, definitely in such cases is not required, my lord. And, my lord, this document is not forgery, my lord. Completely, this was executed between us, my lord. This agreement, my lord, will find at page number 23, my lord. Between the informant and me, my lord. And, my lord, here, my lord will see page number 25. Clause 4, my lord. 33% it's very clear, my lord. And this agreement must, my lord, notarize, my lord. In the Dibrugarh, my lord. My lord, this document is, why should, my lord, I make this document, my lord, and this document is of 2015, my lord. And now, my lord, is this FIR has been filed in the year of 2025. Now, when the money is going to be released?
Tirap is a district.
Tirap is a district.
Near Naharkatia.
My lord?
Near Naharkatia.
Near Naharkatia, from Longding, then Tirap, my lord. From Naharkatia area, that goes, my lord.
And the informant is from?
Informant from Itanagar, my lord.
From Itanagar.
Itanagar. My lord, this is the nature.
He has appeared or not?
Yes, Lordship, on the extent of this interim bail, the accused appeared before the IO, and the document was examined, and the accused was formally arrested and released on bail bond, Lordship. I flagged the relevant place.
No, that is not it. Heard Mr. R. Sonar appearing for the petition. Heard Mr. D. Loy, the public prosecutor for the state of Arunachal Pradesh. But a decision application under section 482 of the BNSS 2023 in respect of Naharlagun Police Station case number 20 of 2025. Where the informant had The informant was awarded a contract by the Director Civil Supplies, Government of Arunachal Pradesh. Stop. On 7th October 2024, he went to that office for pursuing the payment of his bills. Then he came to know that the present petitioner, by forging his signature, made a power of attorney in the name of the informant. Bill paid or not money received or not?
My lord, no money taken.
And the present the informant alleges that the present petitioner, then he found, what did I say? The signature of the informant had created a power of attorney in the name of the informant and was trying to receive the money from the Trade Department. It has been submitted by the petitioner that the informant was given the contract to be executed in the district of Tira. Stop. The petitioner hails from Itanagar. Because of long distance, he took the help of the present petitioner, who is from a place called Naharpatia, which is near to the district of Tira. The informant accordingly had a contract with the petitioner that the present petitioner will execute the work on his behalf, and the total bill amount would be shared between them. So it was agreed by the parties that 33%, what was the amount?
33% of the, my lord.
33% of the bill amount
Yes, my lord.
will be taken by the informant, and the remaining amount shall be taken by the informant.
No, my lord, 33% would be given to the, my lord, petitioner.
33% will be given to the petitioner, and the remaining will be taken by the informant. Thereafter, they had a clash regarding the said distribution of money. According to Mr. Somar, the informant subsequently backed out and did not want to pay the money to the informant. And that is why the false FIR has been lodged. It may be mentioned that pursuant to an interim order granted by this court, the petitioner has already appeared before the investigating officer and has been cooperating with police investigating officer. After considering the submissions made by the learned counsels of both sides, and after considering the facts and circumstances relating to the case, this court is of the opinion that the petitioner, Robin Bukal Sadia, does not deserve to be detained in custody for the allegation brought against him. His pre-arrest bail application is allowed. The interim bail dated 27/02/2025 passed by this court is made absolute. The bail application is disposed of, CD shall be returned.
Dibly.
Item number 14,
Yes.
Lordship, this matter will be passed over for some time, Lordship. The council is stuck in traffic.
Yeah, my lord, this case, my lord, arose out of a complaint dated 38/2019. So what happened, my lord, on the night?
Notice received or not?
Yes, my lord. My lord, this is a joint application for quashing, my lord.
A joint application.
Yes, my lord. No, facts of the case, my lord, may I narrate, my lord?
Please show me the FIR first.
FIR, my lord. Yes, my lord. Oh, this type of cases your lordship has handled, my lord. And dispose of the matter. I have the judgment, my lord.
Page number?
Page number 16 is the FIR.
Please read the FIR.
Yes, ma'am. This to immediately file FIR against one Sri Takam Dolo so and so, who was one of a customer seen in Blues Bar at around 10:45 PM of 29 August 2019. In the beginning, we were sitting in a different table with a bunch of friends of three girls and a boy, and on the other side, he was sitting in a different table taking photograph of us from his phone, and for which I asked him if he was clicking us, but which it was denied by him later. On sensing a kind of insecurity from the men, we were ready for making our way to the home at around 2 AM early morning of 30 August 2019 and started gathering our belongings from our sofa. In the meantime, our hurriedness, we mistakenly picked the mobile phone of that person, my phone, petition number 2, of that person who could have been placed intentionally by that man on our table, but we never knew if his phone was with us. On the way to our home, we heard an unusual ringtone that does not used by any of us, and most probably it could be of that man who we sensed in that very moment. And that was the real moment that we realized that an unknown phone was indeed with us. But we received that phone call and got to know that it was only him. So upon receiving his phone call, we asked him so and so to come and receive it at my residence. But he could not at all listening us and nagging us that we stole his phone. Madam. This is the issue, madam. On reaching our residence, the miscreant arrived suddenly, parked his white Fortuner so and so in dark area and called me to come out. Then I sent one boy and girl to hand over the mobile to him, but they were badly beaten and attacked grievously and subsequently took out his pistol instead and threatened the boy, and by his act of criminality, the boy managed to run away with the girl I sent with towards my residence and directly hide in his room. We then come out from my residence to have a talk of the incident. And in that very moment, he started firing in air, madam. Well, the petition number 2, madam, has not injured anyone from his gun, madam. He has, madam, yes, madam, fired in the air, madam. In the air, his air, and assaulted by slapping me about 5-6 times, molested me, even shot me by pistol, but luckily I was unhurt, and also he started hitting with his pistol and that badly infected my head. I was with full of blood and not knowing that what to do next. He kept on assaulting me physically and wanted me to burn my scooty and to kill anyone who is ever seen driving my car. The whole of the incident happened around my residence, could be in around 3:30 to 4 AM of 30 August 2019. Now, what is the facts of the case on? The facts of the case is that, my lord, we were enjoying in the Blues Bar, my lord, from the night of 29/8/2019, till the morning, 2 AM of 38/2019. Now, my lord, petition number 1, my lord, left the bar, my lord. Now, I went to the reception, my lord, to pay the bill, to clear the bill. I have cleared the bill. While after reaching my table, my lord, I see my phone was missing. So I took a mobile from a waiter and called in my number one. I could not find anyone receiving my phone once. After later on, it was received by the petition number 1. So we had some misunderstanding, and some heated argument ensued. So I said, give back my phone. So I went to his residence. He gave to collect the phone. Now in that moment, I saw there was large number of people gathering to assault me. So to escape from that assault, I blank fired in the air. So there is no occasion of this arms act. Even I was arrested, I have been punished. I was for 15 days in the jail. Now the trial has also not been commenced. In this regard, my lord, what I say, my lord, we have joint, this is a joint application, my lord. And my lord, I have, my lord, may I please come to page 47, my lord. It is not that I am in illegal possession of the arms, my lord. I have a license, my lord, page 47, my lord. 47, my lord, serial number 9, my lord. My license has been, my lord, seized by the IO, my lord. So, my lord, there is no harm that I have not caused any harm to anyone using my pistol, my lord. Ian, my lord, in this regard, my lord, your lordship has also one, my lord, passed a judgment, my lord. And the sections, my lord, the sections that has been incorporated, my lord, has been registered against me is punishment 448, my lord. Punishment for house trespass, my lord. It is not, my lord, applicable to my case, my lord. 323, 354 and 323, 354, my lord. 354 and 509, your lordship has held it, my lord. My lord, may please come to pay para 2 of the judgment, my lord. This was also, my lord, in relation to section 354, my lord, and arms act of section 25 and 27, my lord. Your lordship, my lord, in para 10, my lord, has made a distinction between, my lord, manhandling and assault on the moment to outrage his modesty, my lord. Para 10, my lord. May I read, my lord, para 10. So far as the other offenses are concerned, only section 354 and 148 of IPC are not compatible under section 320 of CIPC. Here in this case, there is no allegation in the FI itself that the modesty of the informant was outraged by anyone. She simply alleged that she was manhandled. Manhandling and outraging the modesty are two distinct matters. Now, both sides have compromised the matter by executing the written deed of settlement, which is annexed with the record. The offenses do not affect the society, therefore, there is no possibility of future conviction of the accused person. In para 12, my lord, your lordship has crossed the proceeding, my lord. And my lord, our high court, my lord, in another judgment, my lord, I think it is there, my lord. 2022 GLT, my lord.
Oh, it is.
Yes.
It is here.
2022 GLT 597.
It is here.
Yes, my lord. Same issue, my lord. Your lordship may come to page 2, my lord, internal page 2, my lord. Brief facts of the case, my lord. Here also the arms act was, my lord, incorporated, my lord. May I read, my lord? Brief facts of the case is that the petition number 2, namely so and so, lodged a complaint against the petition number 1, namely so and so, to the officer in charge of the Nahalagan police station on so and so, stating that the petition number 1 had entered into his private residence on so and showed him a pistol and then went away. After 2 hours, the petition number 1 came back with a gun, pistol, and fired 4 rounds of bullets in the private residence of the petition number 2. Thereafter, petition number 2 again came to the residence of petition number 2 and abused him with slang word and damaged a park car. On receipt of the aforesaid complaint, Nahalagan police so and so was registered with so and so. Consequent upon investigation, charge sheet so and so before the so and arms act, section 27 was also registered, my lord. Now, my lord, in pursuance of the investigation of the charge sheet so filed, charges were framed under so and so. In my case, no charge has been framed, my lord. Now, it is stated that the case is now in the stage of taking evidence, and till that, no evidence has been recorded by the learned court below. In my case, say, my lord, no evidence has been initiated, my lord. Mr. So and so, learned counsel submits that the accused and the complainant are close relatives, my lord. In this case, my lord, this petition number 1 is second wife of my brother-in-law, who is the accused, is the nephew of the complainant, that is petition number 2. He further submits that soon after the complaint as so and so, the petition number so and so complainant went to the officer so and so, praying for withdrawal of the said complaint by saying that they have now mutually settled their differences. However, as the case had already been registered under non-compatible offences, the officer in charge of the Nahalagan police station informed the petition number 2 about his inability under the law to permit withdrawal of the case. Thereafter, by a deed of settlement so and so entered between the complainant and the accused, which is annexed so and so, Mr. Lampu points out that the petitioners, being close relatives, have now amicably settled their disputes, which arose between us of a misunderstanding, and thus so and so uncourteously agreed to withdraw the complaint lodged against him in the so and so. It is further submitted that in the light of the mutual agreement above met, the petitioners have decided to live peacefully together. In that context, it is very unlikely that the complainant will dispose anything against the accused so and so before the land court. The last paragraph. In the instant case, the petitioners who are the complainant and the accused being close relatives and having also stated to have resolved their differences and misunderstandings by agreement dated so and so, it is found that the complainant, petition number 2, is unlikely to give any evidence in connection with the offences alleged against the accused person. So as a result of which, the possibility of the accused being convicted in the proceedings pending before the so and so appears to be bleak and remote, and in that view of the matter, it is deemed appropriate to quash the so and so. Accordingly, it was quashed. Now, my lord, Rama, my lord, even if there is a special act, my lord, it can be quashed, my lord. Year 2021, SC 5228, my lord. Now, para 16, my lord. May I read, my lord? On the other hand, where it appears to the court that the offence in question, although covered under the SC/ST Act, is primarily private or civil in nature, or where the alleged offence has not been committed on account of the caste of the victim, or where the continuation of legal proceedings would be an abuse of process of law, the court can exercise its power to quash the proceedings. On similar lines, when considering a prayer for quashing on the basis of a compromise settlement, if the court is satisfied that the underlying objective of the act would not be contravened or diminished, even if the felony in question goes unfinished or unpunished, the mere fact that the offence is covered under the special statute would not refrain this court or the High Court from exercising their respective powers under Article 142 of the Constitution and Section 482 of CRPC. So, my lord, what I pray, my lord, since we have amicably settled the matter, my lord, our settlement is at page 44, my lord. Here also, my lord, the settlement facts, my lord. Facts of the settlement is there, my lord. May I read the facts, my lord, of the settlement, my lord. Page 44, my lord.
Yes.
Yes, ma'am. The facts, ma'am. This is the real facts, ma'am. Whereas on 29/8, so at around 10:45, the first party along with his friends went to Blues Bars located at 0. Tinali, Itanagar for some drinks, wherein the second party along with her friends also came at the bar and sat at the next table to the first party. Their conversation started and they got friendly with each other. Later, after finishing their drink, the second party and her friends left the bar prior to the first party. Thereafter, when the first party was about to leave the bar premise, he searched for his mobile phone but was unable to find it. Malad, the main issue, Malad, is the this missing of this mobile phone, Malad. As such, he borrowed the waiter's mobile phone, Malad, and called up his phone number. Initially, no one answered the phone. However, upon constant redialing, a lady answered the phone and there was some verbal argument between the parties. However, the first party was later given the direction to the resident of the second party to collect his mobile phone. Upon reaching the said address at Dudas and so and so, so the first party saw some people gathered near the residence of the second party and charged him with punches and beaten him with the sticks, on which the first party, in order to get out of the dire situation and save himself, taken out his license gun and blank fire in the air. Thereafter, sir, diligence came and first party left the place of occurrences. The facts of the case has to be appreciated. Even these days, even the rape charges are also passed, taking into account the facts of the case. Here also, I have not injured anyone. I have blank fire only to escape this crowd. Otherwise, I would have been beaten. So, I pray this.
Yes, Your Lordship. Your Lordship, with regard to 354 and 506, Your Lordship, since this does not comes into public harm, Your Lordship, it's individual. Therefore, I don't have any objection with regard to quashing on that sections. However, Your Lordship, 25 1B and 27 of Arms Act has been charge sheeted, Your Lordship. My only contention is that even this sections does not come. Why? Because the sections were put because he did not deposit his arms during election, general election, which was held in April 11, 2019, and the FIR is post-election. So it does not even come. The second is that his license has been expired, Your Lordship. For any expiration of the license, Your Lordship, there is a provision under the Arms Act itself that it can be revoked. Your Lordship will see Arms Act Section 15, Your Lordship. Section 15, 16, 17 is the provision where if the arms is to be renewed, the license of the arm is to be renewed, and if not renewed, the provision of suspension, revocation is provided, your lordship.
Now, on the date of the occurrence, was the license a valid one?
As per the charge sheet, your lordship, it has expired, your lordship. My contention is that even if the license has expired, your lordship, there are provision under the act, under section 15, 16, 17, that the only provision for expiry of a license is revocation, seizure, your lordship. And section 18 speaks about appeal. So it does not come into picture in this offense, your lordship.
Already repairs, my lord. There is no
Therefore,
offense, my lord.
since in 27, your lordship, there was already license. 27 speaks about infringement of section 5, your lordship. Section 5 does not apply to the arms which has license, your lordship. Therefore, as such, in merit, your lordship, with regard to Arms Act, your lordship, I'll only submit.
Cost.
My lord, deeply aware.
Deeply.
Lordship, on the last occasion, TCR was called, Lordship. This is fourth time, Lordship. TCR has been called.
Received or not?
That is a receipt, lordship.
It is received. It is received.
Lordship, here, Lordship, I have a limited prayer, Lordship. Just an opportunity may be given, Lordship, to me, Lordship. Because, Lordship, during framing of charges, Lordship, the counsel for the accused was absent, Lordship. But the accused is present, Lordship. It's session code, Lordship.
Counsel for the petitioner was absent.
Yes, Lordship. But accused was present, Lordship. Applicant here, Lordship.
And
So,
charge
Lordship,
present.
applicant, Lordship, inform learned session court that the counsel is out of session due to some urgency, Lordship. But the learned session court failed to acknowledge that and frame charges, Lordship, against that. In fact, Lordship, in charges also, Lordship, there is nothing has been adverse against me, but Lordship, today I am not going into that merit, Lordship. At least one opportunity may be given, Lordship, to me, Lordship, for reconsideration of charges, Lordship. That is my only limited prayer, Lordship.
Lordship, here, Lordship, section, Lordship, 228 of the CRPC, Lordship. It is up to the Lordship, court to decide, Lordship, because if the sufficient ground is there, Lordship, then it can be presumed, Lordship, that the accused has committed the offense that day, it can be charged, Lordship, even though, Lordship, accused is not, accused counsel is not present, but accused is present, was present at that time. May Lordship, in the CRPC, Lordship, wherein the Lordship, this comment section is reflected that the prima facie case is to be seen only for the framing of charges under section 228, Lordship. And just, Lordship, it is not required to record detailed reason for framing of charges under section 228 if there is sufficient ground to presume that the accused has committed the offense.
There has to be, Lordship, after the argument, Lordship.
Lordship,
After argument, Lordship, learned session,
Lordship, they say, Lordship, if the judge, then they have opportunity to, Lordship, on the next date, Lordship. In the order they have challenged, the next date is fixed on the 1st of April for the appearance of accused person and examination of PW. At that day also the accused person appearance is, Lordship, they call for, Lordship.
There is only one accused.
two accused.
Two accused, Lordship.
Lordship, regarding that, Lordship, I have some citation, Lordship.
So, Lordship,
I
why
would like
this?
to-
Yes, Lordship.
You heard the learned counsel, Mr.
Ji, Jini, Lordship.
G. Ginny. Appearing for the petitions. Heard MS L. Hagedi learned to reasonable prosecutor for the state person. This application has been filed under section 438 of the BNSS 2023. Challenging the order dated 13/11/2024, passed by the learned sessions judge UPI. What is the case number?
Lordship, session case number 54 of 2022.
In sessions case number 54 of 2022. Yeah, by the impugned order, the learned court below framed the charges under sections 341, 323, 307, of the Indian Penal Code. Read with section 34 of the state code.
Read with section 25 IA and 27 to Arms Act also.
Read with section 34 of the state code, as well as under section 27 of the Arms Act.
25 1A and 27 2.
Charge frame under section 27.
Yes.
The petitioners have submitted that on 13/11/2024, their counsel was absent in the court, and therefore they prayed for providing them another opportunity for hearing their learned counsel. But the court below did not allow their prayer and framed the charges. Para. I have considered the submissions made by the learned counsel to both sides. Para. Providing opportunity of being heard is a basic foundation of our judicial system. The learned trial court has committed the mistake by not hearing the counsel for the petitioners before framing the charges. Therefore, the impugned order is bad in law. The impugned order dated 13/11/2024 whereby the court will framed charges against the petitioners in respect of sessions case number 54 of 2022 is set aside. Para. The learned session judge is directed to hear the petitioners and thereafter shall pass appropriate orders as prescribed by law. With the aforesaid direction, the revision petition stands disposal.
Lordship, moreover, Lordship, I have some further submission that under 311 CRPC, they can file recall application before the session court also for the recall of that order, Lordship. They have the provision on that also.
311
they
is
have
for-
not,
311 is for recalling witnesses.
Lordship, that is there, but they have, if
But
they.
nowadays it is also difficult. There is a judgment of the Supreme Court.
Lordship.
Recalling witnesses is also difficult.
Right, Lordship.
Highly over.
Item number 14, password for the timing matter.
This is the second anticipatory bail.
Earlier one was rejected. The initial one was rejected.
Initial one was rejected, Lord.
Where is the order?
But there is impugned order is also on the record, Lord.
Page number 18, Your Lordship.
No, this is a loose sheet, actually. It was filed later on. Impugned order is,
No, what is the new ground?
my Lord.
What is the new ground?
But the ground is, my Lord, actually he is in a critical medical condition, my Lord. And this plea was not actually taken at that time. That is the reason, my Lord. This is the second application, my Lord.
You see, one thing is there. This is not an appeal.
This is not the appeal. This
This
is not,
is not an appeal.
this is not appeal.
So if one application is rejected by this court, and if you want to file another bail application,
Exactly, my Lord.
you have to show a new ground.
My Lord, correct. But actually, if my Lord may kindly see the order, the impugned order, my Lord. The factual finding is, my Lord, at page 11.
No, I have already told you, this is not an appeal. I cannot.
No, that's
go
why
in-
I'm saying, that's why I'm saying, that's why I'm saying. What I'm saying is, my Lord, I'm not pleading what has already been pleaded, my Lord.
I cannot read this order also. Because one thing I know that you.
Just for the reference sake, Lord, I'm not raking up anything which has already been pleaded. Like material, like factual things, I'm not pleading, Lord. This additional medical thing, if I can win my Lord's confidence, Lord, that is for that sake that I'm here, Lord. And medical is not an ordinary medical condition, right? He was actually before hospitalized in Guwahati and then airlifted by an ambulance to Max Saket, Lord. So this is an extraordinary medical condition because of which I had to rush to this honorable court point this out. And this forms a ground, if not an additional ground, but this forms a potential ground, right? To be
What is the background of this case?
the background, my lord, yes. If I'm not seeking the review, my lord, the background is that I am attempted to be connected very remotely, alleging against me that I had got 3 phone calls from some unknown number. This is the only allegation against me. And if I am allowed to, my lord, read the conspiracy section 61, my lord,
Where is the FIR?
FIR, my lord, yes. My lord. FIR is at page, my lord, 89 of the paperwork. Nothing against me.
Page number?
89, my lord, of the paperwork. I am not the committer of the act, my lord. My plea of alibi is an admitted fact. Prosecution is not disputing this plea. I am a block education officer, was performing my duty, is not disputed, my lord. And I should not say, my lord, in the first bail application, my lord, this court was not properly assisted. So this I'll submit only when I'm called upon to submit on the facts of the case, my lord. Otherwise, medical is what prompted me to come to this honorable court, my lord. He is into extraordinary medical condition, my lord. He cannot be even arrested, even if I am sought to be remotely connected. If my lady friend can assist the court, my lord.
Wait a minute.
My lord.
Jenny,
Yes, your lordship.
regarding this incident,
Yes, your lordship.
there was probably another bail application.
Yes,
that,
your lordship. One of the main accused bail was also rejected and was directed by the apex court to surrender, your lordship. The same case, your lordship.
Went to the Supreme Court.
Yes.
I remember. Who is the present petitioner?
He is also the brother of the deceased, your lordship. Not the deceased, I mean, as per the FIR, your lordship,
She was
He's
also
a relative, my lord. He's a relative in whose house the
Lordship,
conspiracy was hatched. I am for the complainant. I'm sorry, I'm intervening.
He was also
He's
taking
a
treatment in Max Hospital, Delhi.
yes, your lordship.
Lord, yes.
Medanta
Vedanta
Hospital
City
in
Hospital.
Delhi.
I remember. Now, this petitioner is also taking treatment in Max Hospital, Delhi.
Yes.
yes, my lord.
So all are in Delhi, probably.
Currently also, my lord, he lodged in the hospital there.
Did you place these documents and
Actually, that time they were not on the record. Lord. So that's why I had no reason to go in an appeal also, because without reading the same before this original court of jurisdiction, Lord. And this is a very vital fact which was missed out that time, Lord. And not that he has been flown or airlifted just for the sake of bail. Lord, he was airlifted a long back. Even before filing of this application, Lord. So first bail application, Lord. And secondly, Lord, the plea of parity also was not effectively raised, my lord, by before because all of them, almost all of them.
Principle of parity is not applicable in
Correct. But they have implicated left, right, center, and this material is before this honorable court. That they have, there's no application of the mind. Two people. Correct.
Once it is rejected, you have to show.
Correct. I'm not. That's why I'm not on that.
What is your new ground? Medical ground.
Medical ground. If my lord, I can show my lord the particular thing, my lord, the photograph is at, my lord, 283 to 84 of the paperwork, my lord, showing that in which, what kind of condition he is into. 283 to 283 of the paperwork, my lord. And then I can take, my lord has 283, 383, my lord, 383 of the paperwork. 383, 384. They show that, show his condition, my lord, in what kind of condition this man is into. 383, 384 are the photographs. If my lord,
I will have to ask for a report from this Max Hospital Delhi.
definitely, my lord. I'll be up to that.
I'll just surprise your lordship.
Huh?
Lordship.
Definitely,
Okay, Mr. Tiwari, who can get that report? Delhi Police.
definitely.
My lord, may direct a medical board to be constituted either by Max Hospital itself or any government hospital in Delhi, my lord. They can visit Max and do it under orders of this court. That can be AIMS in Delhi, Safdarjung Hospital, or the local chief medical officer of Delhi can also, my lords, assist the court and give this report to my lords. The local jurisdictional CMO, my lords, would be the appropriate person. It is my humble suggestion. He can visit Max Saket, get the records and give a report and assist this court, my lords.
This Max Hospital is in Saket.
It's in Saket, Delhi. It's in Saket.
It's
Then I will
a
ask the
private
Max
hospital.
to file a report. I will ask the
Of
Max
course,
Hospital to file a report. To
Of
constitute a
course, that
medical
is
board
very fair, my lord.
and file a report.
Yes, in fact, I was about to come, your lordship, that on the day of the rejection of the bail, the ground given is on the day itself when the bail was rejected, he was admitted to the hospital, your lordship. Now, these all documents, since his rejection, he has never appeared before the IO, your lordship. Neither these documents were at least given to the IO so that to at least get some time for his treatment. Nothing was given to us, your lordship.
She's right,
It's
my lord.
put
That
into
time documents were not there. She's
Okay, all right.
fairly stated.
Heard the legal counsel, Mr.
Sushil Sharma, my lord.
Sushil Sharma, appeal for a petitioner. Heard MSJ T. Gini, the learned additional police prosecutor for the state of Assam. Heard Mr. Tiwari, A. Tiwari,
Oblige, my lord.
appeal for a informant. Para. This is the second bail application under section 482 of the BNSS 2023. After rejection of the earlier one, I will quote on 07/01/2025, filed AB number 158 of 2024. Para. This application, the present application has been filed on medical ground. It has been submitted that the petitioner has been taking treatment at Max Healthcare Hospital at Saket, New Delhi. Therefore, the Max Healthcare Hospital at Saket is directed to constitute a board, medical board, to examine the health condition of the present petitioner. What is the name of the petitioner?
The Ashim Lamgu.
Huh?
Ashim Lamgu. ASHING. Ashim Lamgu. LAMG.
Lamgu is before Ashim.
Ashing, ASHING, and Lamgu, LAMGU.
Ashing, ASHING, Ashing. Lamgu, LAMGU. After that, a report shall be sent to this court. The entire exercise of examination shall be done within next 15 days from today. So list this matter after 15 days.
On the last date of hearing, my lord, I could not get the interim order, and the interim order was to be considered today, my lord. This is what the last order says, my lord. So interim order, my lord, in this file, my lord, which will be justifiable also.
No, he's
It
not.
was to,
My
it was to be
colleague
considered
had
today.
said he's not being arrested. My colleague had just said that he doesn't really have an apprehension of arrest. My request would be that the government counsel is there. In a case like this where he's not been arrested for 3 months since the dismissal of the last bail, the apprehension is less. I leave it to the court, Malaj. My only submission is that interim may be held off till the report is.
I will continue it. The interim prayer shall be considered on receipt of the medical report.
My lord.
Yeah.
Your lordship, if I may, your lordship, the information to the max shall be done by the registry or
By the registry. it will be.
registry. Deeply.
My lord. Grateful.
Obliged.
Deeply.
Yes.
My lord, there was a misunderstanding between the accused and the victim.
Which one?
They went down from Itanagar to buy muttons in Nirjuli. And then what had happened, the victim, that point of time, my lord, he also used a knife. So then there was an altercation, my lord. And then the FIR was filed.
What is the FIR?
FIR is at complete page 17, my lord.
Page 18.
18 is the type copy.
Mr. Tara, please read the FIR.
Yes. Hey, I would like to draw your kind attention that 22nd February at around 6 p.m. at Lekhi, two boys came with a Bolero bearing number AR 01E9100 near Mutton Shop Lekhi, and started beat punch to my husband. While my husband wait for tempo vehicle for Itanagar. After repeatedly punching to my husband by two boys, my husband trying to defend himself with his knife. Few minutes later, beated my husband in unconscious condition. They were abducted, kidnapped. Well, take him with their vehicle towards the railway station, Borum, and they throw him. My husband's reso near Backside Drain in unconscious condition near Borum. This very unfortunate that intentionally trying to kill my husband's resource. Well, both of them were not, they are unknown.
Oh.
Well, both of them, now it is settled, my lord. That only thing, my lord, I would request, my lord, I just write from the proposition that started from Gyan Singh, my lord. Gyan Singh, my lord, paragraph 2012, 10 SCC, my lord, I just, and then thereafter, this is a settlement. So Gyan Singh is the, my lord, leading case, and then, my lord, that I'll furnish the judgment, my lord. Yes, 2012, 10 SCC.
You give me the citation.
I'll give the citation. Then, my lord, that the base part later on is the Lakshmi Narayan, that paragraph 30, my lord, is aware on the settlement. So now
both the citations.
I'll give both the citations. My lord. I think
Yes. Okay, how do you understand?
mutual settlement is that. That's one.
Offenses, your lordship, the TCR, your lordship, has been called for, but however, it has not been received. But your lordship will proceed with the hearing, your lordship. Have to see the sections, your lordship, whether the sections are heinous or not, your lordship, because your lordship, the Bhajan right from the Gyan Singh and Bhajan Lal is also there, your lordship. Lakshmi Narayan's case says when it comes to the heinous offense, then and the offense which of moral mental depravity, your lordship, the court should refrain from exercising its power under 482 or now it's 582, 528, your lordship. So whether this class of offenses will fall under the category of that class of that offenses or not. If not, then your lordship, if the party has settled, then it can be quashed.
But that kidnapping.
In Gyan Singh, the heinous means rape or like that.
Your lordship, if may I please, your lordship, so far as the classification of offenses, your lordship, it is not defined in the IPC, neither in CRPC.
Correct.
But your lordship, the same is there in the JJB Act. And JJB Act, your lordship, the Supreme Court has dealt with it, where Honorable Supreme Court has held that the offenses where the minimum or the more than 2 years, but it goes, even if it goes to life or death, it will come under the serious offense. But if minimum is 7, and if it goes upward, like that, then that will be a heinous offense. So any offenses, your lordship, more 3 to 7 or more, your lordship, even 10 years, this will fall under the category of serious offenses.
Here the offenses are under section 367.
Yes,
325. 201.
325, my lord, there is one judgment by Justice Ete Charu Prasad. That will also, I will also place. Yes, compounded.
Three, so far as 326 is concerned, your lordship, the recently honorable Supreme Court has held that.
There is no 320, 325.
325, yes.
Yes.
325, your lordship,
And 367.
360.
What is 367?
Yes,
Kidnapping.
that we have to look into. your
Kidnapping,
lordship.
kidnapping, my lord, basically what happens, without fire anything and then using arms, and then there should have been some intention of ransom or something. But here, my lord, FIR content of the FIR itself discloses there is nothing as such. Out of a misunderstanding, there was a heat of motion, and then they started fighting. And then, my lord, the weapon was used from the other side. So that's, my lord, that settled it, my lord, then. My lord, I'll provide kindly interpret.
Your lordship, because 367 say kidnap or other thing in order to subject to person grievous hurt, slavery, etc. So now here, your lordship, the punishment is extend up to 10 years. So it's a serious offense, no doubt. It doesn't fall under the category of heinous. But your lordship, so far as to causing grievous hurt and all, that all this aspect can be, your lordship, or whether any other weapon has been used or not, that can be ascertained from the, your lordship, TCR. Because here, your lordship, this is only the petition. We have not received the case diary. Because, your lordship, the FIR is not an encyclopedia of entire fact, your lordship is very aware.
My lord, I am not arguing on merit. It is purely a compromise. So, my lord,
Okay, it is first.
like, grateful, my lord.
This is a joint application filed by the victim and accused persons.
Where is the FIR?
FIR page number 45, my lord.
45.
Yes, my lord. My lord, in page number 48. Sorry. Page number 48.
48.
Yes, my lord.
Could you please read the FIR?
Well, with reference to the above subject stated above, the undersigned is agony to state that during the performing my duties as a sector magistrate at Pekimodi polling station under 40 Marange constituency, which is very interior, and took a day to reach the polling station by foot. On the full day, that is 19 April 2024, around 1:30 a.m., 11:30 a.m., a group of people led by Sri Sasensas residing at the Mariang attacked the polling team and lifted me and kept in the house of Sri Belum Modi Gaubura and false case against me and forcefully demanded me to rupees 1,50,000 as a ransom of the polling team. They said if their demand has not been paid, the polling team will not allow to leave the Pekimodi and treat to kill one by one, and gave account number of Google Pay number, such and such. Therefore, I earnestly request you to kindly register a case against kidnapping case.
Now compromise them.
Yes, my lord. My lord, actually, this affair was filed after a Kebang decision. My lord, kindly see at page number 43.
43.
Yes, my lord. Married, my lord. Just a minute. On 19 April 2024, Sri such and such from Mosing Village POPS in Upper District, Arunachal Pradesh, who was a sector officer at the Pekimodi polling station, attempted to manhandle the public of Pekimodi by using matches. While serving as the sector officer, his actions were deemed unacceptable and the issue was resolved with local council Kebang, and accordingly a fine of rupees 1,50,000 only was imposed on him, which later he paid. Additionally, it was decided that this issue should not be made viral on social media. My lord, the applicant number 1 is the victim, and he was imposed fine of rupees 1,50,000. After agreed by this Kebang decision, he filed a FIR before the Marang PS, and same was registered at Marang PS case number.
Now what happened? Now they have compromised.
Yes,
Yes,
well,
Lordship. They compromise, but Lordship, on the last occasion, TCR was called for, but
Since they have compromised, there is nothing left now. Okay, it is first. Okay. It's safe. Huh? Okay, there.
Your Lordship,
Yes.
one prayer, Lordship. I beg to mention item number 9. There is an interim order which was taken up this morning. Kindly it may be continued.
Item number 9.
Yes.
You want it to be taken at 2.
Item number 9, Lordship, it was first.
Already
was
passed
taken,
out.
Lordship.
Taken up this morning, yes, yes,
It was
yes.
taken up and it
Okay.
fixed on the month of April. Sorry, after the break.
After the break.
Yes. It was already taken.
There is an interim order. Kindly it may be continued.
Hmm?
Interim order is there, Your Lordship.
Oh, the
Kindly.
interim order passed. Let us
Yes, yes.
continue until.
Obliged.
Obliged.
Oh, okay, then. F2.
My Lordship, please. Lordship, I beg to mention one unlisted matter for listing of tomorrow.
You come tomorrow morning. Mention it tomorrow morning, not now.
Yes.
May it please your Lordship. Your Lordship, in the last occasion, White order dated 7/3/25. Seven three 25, Your Lordship. Your Lordship will find in paragraph 6, Your Lordship. May I read, Your Lordship, operating portion? Paragraph 6. After hearing the submission made by the learned counsel for both the sides, it seemed that the petitioner has been cooperating in the investigation of the case. The case diary also revealed that the statement of the accused petitioner has already been recorded and the injury report has been collected by IO. However, considering the submission made by the Mr. Baum, learned counsel for the informants, I find it necessary to call for a detailed report from the concerned IO as to whether there has been any violation of the terms and conditions of bail, or if there has been any development involving threatening of witness or the informant of the accused person petitioner. So, Your Lordship, I have received the status report. May I read the status report, Your Lordship? On 26/2/2025, another FIR received from Sri Perlu Basar, this is the victim, against accused and their family member for impulsion attempt to pressurizing him to withdraw and negotiating of the case. Accordingly, I have conducted an investigation. I have examined the family members of the complainant present there, and further I have examined the other persons who were visited them for the negotiation of the case locally on behalf of Sange Chukla, this is the accused, and Tenjing Chukla, co-accused. During investigation, it has been found that four senior person, namely Tinle Sona, aged 83 years, son of so-and-so, Sri Kunsang Naksang, aged 58 years, Sri Jamba Pille, 51 years, Karma Mindu Pille, and Sri Sange Chukla, 57 years, teachers, went to the resident of Perlibasa, that is the informant victim, voluntarily without the consultation of the accused, alleged accused, for negotiation the case in local system Kabang, and during the negotiation, they have requested the compromise the case as per either the Galo customary law or member customary law, and they also agreed that they will come to Alo for settlement if required. And further, they said that the boys who did this were police and should not have been done, but it's already been done. And further, Perlu Basar will have to work in Mechuka, so it is better to solve the case locally. And but the family member of the complainant rejected the request and stated that they were not here to solve the case locally. They were here just to seek update of the case from the police. And after many requests, they have left from the residence of Perlu Basar. Hence, during the inquiry, it has been found that four above mentioned person of member community of Mechuka went to residence of Perlu Basar at around 8:30 a.m. for negotiation of the case in local system. But the family member of Perlu Basar denied their request. Here, Your Lordship, it says they voluntarily went, not under the direction of the accused person.
So meaning thereby, your lordship, there is no any violation of the condition, your lordship.
Okay, heard the learned counsel, Mr.
Sushil Sharma, my lord.
Sushil Sharma.
May I please, your lordship?
Yes.
Your lordship, I am appearing for the victims, your lordship. Your lordship, as my senior has already read out the status report, there is a specific amendment that 4 senior members from the member community has went to the house of the victim and they have requested them to settle the matter. Your lordship, whether they have been went to the house of the victim voluntarily or they have been sent by the accused person, it cannot be determined. Furthermore, there is a specific amendment that Palul Basar has to do work at Mechuka. It means they are threatening your lordship. So, your lordship, I am just humbly praying that I may furnish this status report and make allow me to making my submission on tomorrow. Your lordship.
You cannot get the report because
Yes.
your duty is to assist the public prosecutor.
That is there. But your lordship,
Public
there is
prosecutor
a
will be
specific
always-
violation of the your lordship.
You have no specific role. Actually.
And your lordship, 170 of the CRPC also prevent them, 172 of the CRPC also, your lordship, doesn't provide any right to access of the case diary. Any status report is a part of the case diary. But your lordship, I have already submitted that the four senior members from the member community has went to the house of the victim. They have tried to induce the.
They belong to 2 different communities.
Yes, your lordship. The victims belong to Galo community, and the accused person belong to a member community. The 4 senior members went to the house of the victim. It is admitted in the status report, and there is a specific amendment that the Palul Basar, who is a victim, has to do work at Mechuka. It means they are threatening. If you are not going to settle the matter, you will not be allowed to work at Mechuka. It seems like that. There is a specific violation of the condition laid out by the honorable court. So I humbly pray that here interim.
Heard Mr. Sushil Sharma, appearing for a petition. Heard Mr. T. The learned petition of public prosecutor for the state of Arunachal Pradesh. Heard Mr.
Irak Bam.
Appearing for the informant. Where this is an application under section 482 of the BNSS 2023. Praying for pre-arrest bail in respect of Mechuka PS case number 01 of 2025. Under sections 333 stroke 155 within bracket 2 stroke 3 within bracket 5 of the BNS.
Your lordship, 115. 115.
115 within bracket.
Yes, 115 subsection 2.
3 within bracket 5 of the BNS. Radio section 3 of the Prevention of Damage to Public Property Act 1984. Where?
And your lordship, 2 more sections were inserted, your lordship, during the interim protection, when interim protection was extended. That is section 140 and 140 subsection 3, that is kidnapping or abduction. And the other one is 127.
Of BNS.
Yes, your lordship.
Then after this
During dependency.
After 3 within bracket 05 again stroke. What is it, the section?
140 subsection 3.
140 within bracket 3 and
127.
127 of BNS, radio section 3 of the said act. Pair. This court, on 07/03/2022, granted interim bail to the petition. And pursuant to the interim order, he has already appeared before the investigating officer and his statement has already been recorded. Fair. Interim bail was dated what date?
Your lordship, interim was initially granted on 7/3/2025 and it was extended on 7/3/2025.
It was extended on.
Initially from the other. 7/3.
Initial-
7th of March. No, your lordship.
Initial-
Interim was granted on
initial-
19. Initially, it was granted on 19/2/2025.
Granted interim bail on 19/2.
Yes, your lordship,
19/2, 2025.
And further extended on 7th of March.
Okay, just a minute. It was extended on 07/03/2025.
Yes, your lordship.
On that day, the informant objected to the bail application. Therefore, this court directed the investigating officer to file a report as to whether there has been any violation of the terms and conditions of bail order. Today, the aforesaid report of the investigating officer has been placed before this court. And on a plain reading of the said report, it appears that there was no such violation of the interim order granted by this court. The learned counsel for the informant has already objected to the bail prayer and prayed for some time to submit his case, submit his arguments. This prayer is rejected because the role of the informant is to assist the public prosecutor only. The informant does not have any independent role in such matters. From the report of the investigating officer, it appears that there is a clash between two different communities, and each of them are justifying their case and bringing on allegations against each other. I have considered the submissions made by the learned counsels on both sides. Putting a person in judicial custody is done for investigation of a case. If a person accused of committing an offense cooperates with the police investigating officer, he does not deserve to be detained in custody. Here in this case, the petitioner has been cooperating with the police investigating officer, and therefore he does not deserve to be detained in custody. Therefore, his bail application is allowed. The interim bail granted by this court on, what was the date?
19/2/25.
19/2/2025 is made absolute. The bail application is disposed of, CD shall be returned.
Deeply obliged. And your lordship, case note, the dates are different. And item number, your lordship, 12 is the co-accused, wherein your interim was extended on 21/2/2025.
He has appeared or not?
Your lordship?
He has appeared or not?
He has also appeared, your lordship. His statement was also recorded. Your
So make it one thing. This is a common order for these two items. Put a line there. For item number 11 and 12. This is a common order for these two items. Heard the learned counsel so and so, so and so, so and so. Interim bail granted on same date.
No, on 21/2/25.
The interim bail orders granted on
21.
One is on 12.
Yes, one, your lordship, one is on 19/2, which has already been passed.
2025 and on
21, oh no, your lordship. The purse was on 21/2/2025, and the second one is on the same date, your lordship, 7/3/2025.
Are made absolute.
Yes. Obliged.
Both the bail applications are disposed of. CD shall be returned.
I'm good. Obliged. Highly obliged.
I for what?
Your Lordship, this I is for condoning the delay of 61 days in preferring the connected make appeal.
At this stage, notice will go.
Yes, Your Lordship.
Heard the learned counsel, Mr.
M. Tangzang.
M. Kangan, appearing for the applicant. Issue notice to the sole respondent. The applicant shall take steps for service of notice upon the sole respondent by registered posting AD. List after 4 weeks.
21 and 22 also connected, Your Lordship, arising out of the same accident.
The same order.
Yeah, from 20 to 22.
20, 21, 22, same order.
Much obliged, Your Lordship.
23. Yes, I have already heard him.
Petitioner side already
Already heard.
Yes, now our side. I will take not much time, Your Lordship. Now, Your Lordship, initially, Your Lordship, they have raised objection on the admissibility of the confessional statement. Your Lordship, because in this case, basing on the confessional statement and with the corroborating other evidence, the accused has been convicted. So now, Your Lordship, their first line of argument was that it was recorded by the executive magistrate. Now, Your Lordship, very interestingly, Your Lordship, the offense is committed long time back in 2012. Now today is 2025. There is a substantial development in the judiciary in Arunachal Pradesh. So now Lordship, I will directly take Your Lordship to the section 3, which my brother has, Your Lordship, oversee or overlooked, Your Lordship.
Section 3 of BNS.
No, CRPC, Your Lordship. At that point of time, the CRPC was prevailing.
Section 3.
Yes, Your Lordship. Section 3, Your Lordship. And in section 3, Your Lordship will find in the page number 41, right side, Arunachal Pradesh, Mizoram, and Meghalaya.
Just a minute.
Yes,
Section 2. The 3, construction of reference.
Yes, construction of reference. Your Lordship will find in the state amendments, Your Lordship. State amendment, Your Lordship, find the name of state Arunachal Pradesh, Mizoram, and Meghalaya.
Where it is mentioned?
In the state amendment column, Your Lordship. State amendment, yes. Yes, Your Lordship. Now may I read, Your Lordship. In its application to the state of Arunachal Pradesh, Mizoram, and Meghalaya, in section 3 of Code of Criminal Procedure 1973, 2 of 1974, after subsection 4, the following subsection shall be inserted, namely, notwithstanding anything contained in foregoing provision of this section, any reference in such of the provision of this code as applied to the Union Territory of Arunachal Pradesh and Mizoram to the court mentioned in column 1 of the table below shall until the Court of Session and Court of Judicial Magistrate are constituted in said Union Territories to be construed as reference to the Court of Magistrate mentioned in the corresponding entry in column 2 of that table. Now, Your Lordship may come to the next page. The table, it says, Court of Session or Session Judge of Chief Judicial Magistrate, District Magistrate.
Where it is? Section 6.
No, Your Lordship, it's in continuation of that, Your Lordship, the amendment provision. The Court of Session, Your Lordship, find.
Table.
Yes, table, Your Lordship.
Table. Court of Session.
Court of Session or Session Judge or Chief Judicial Magistrate, District Magistrate. Magistrate or Magistrate of the first class or Judicial Magistrate of the first class, Executive Magistrate. Now, Your Lordship, at that point of time, the Chief Judicial Magistrate, Judicial Magistrate first class, they were not appointed at all. it was discharged, that power has been conferred to the executive magistrate. And executive magistrate were discharging, they were empowered to discharge the power of judicial magistrate first class. And if they are empowered, they have well within his jurisdiction in recording the confessional statement. So that ground goes, Your Lordship. And now, Your Lordship, further to substantiate that submission, Your Lordship, Your Lordship will find this notification, this is a copy of the notification. They were appointed in the year 2023 or 2013, Your Lordship. An incident and the recording of the statement was on 2012, Your Lordship. Your Lordship, the first column is, Your Lordship, the grade 2 officers. They were Chief Judicial Magistrate. And Your Lordship will find in the second page, the Judicial Magistrate first class. So my brother was correct, Your Lordship, to recording the statement under 164, it has to be done by the judicial magistrate. To that extent, he is correct. But the executive magistrate who recorded the statement in this case was empowered, and he is acting as a judicial magistrate first class, which is clearly reflecting in the confessional statement itself. Now, Your Lordship may kindly come to the confessional statement.
At that time, there was no judicial magistrate.
No judicial magistrate, Your Lordship. Your Lordship will find in page number 11, Your Lordship, of the paper book.
Yes.
Your Lordship will see the signature of magistrate, judicial magistrate first class. Changlang AP. It is not a case where signature has been made by the executive magistrate, then at least inference can be drawn that he was not empowered. But now it clearly says it is empowered. And now Your Lordship will also find in this deposition of the magistrate that nothing in the cross-examination, they were ever put the question that he discharged his duty as an executive magistrate or the judicial magistrate. Now, at this stage, at the appeal stage, if such question has not been put before the concerned officer, concerned magistrate, they cannot raise this issue here. Definitely, there will be a presumption that the officer has been discharged his duty properly under Section 114 of the Evidence Act. So far as the plea is concerned, to that extent, it is admissible. Now, secondly, now we have to come to the voluntariness, Your Lordship. They have retracted his statement only during 313. I will, Your Lordship, come to 313, Your Lordship.
Page 73.
Page 77, Your Lordship, the retraction part.
Yes.
Your Lordship will see in question number 25. Here, that the PW8 magistrate SS Chaudhary stated to have recorded your confession statement in 14.9.12, wherein to confess to have killed the deceased with a sharp weapon. What do you say on this? His answer: though he recorded my statement, I do not remember. What I have stated as there was public pressure. Public at the time of recording my statements were present outside the court of the magistrate. They even tried to attack me while I was in the police custody. I have given my statement under pressure. Now, Your Lordship, basically, retraction when voluntariness, Your Lordship, in the Catena of judgment, it has been held that normally pressure was normally given from the police by way of duress, threat, or promise. In most of the cases, Your Lordship, there is a promise to make approval. Later on, they withdraw their promise. And so far as pressure is concerned, Your Lordship, the pressure regarding, Your Lordship, if the person, when person is in police custody. Now, here in this case, he was produced from judicial custody. Which same is there, Your Lordship will find in the confessional statement. He was produced from the judicial custody. Judicial custody meaning thereby he has given more than 24 hours for reflection. And even after that, when he was brought before the magistrate, all the formalities procedure has been complied with. Your Lordship, the condition, the sine qua non for 164 is that he is not bound to give confessional statement if it is if he voluntarily give the statement, it shall be used as an evidence against him. That part has been complied with. Your lordship will come to page number, your lordship. I will now, my brother has not actually read out the confession statement. I will read out the confession statement. Your lordship, from page 8, your lordship.
Page 8.
Yes, your lordship.
Oh, yes.
Yes, your lordship. Now you see from 3. Having talked with accused, explaining to him each of the matter mentioned in paragraph 5 hereunder, and caution his that she quote to neglect carefully before making a statement. I have placed her in charge of the peon Taju so and so inside the his courtroom, your lordship, and with the peon, police was not there, and directed the accused to wait in one corner of my office room in order that he may have time to reflection before making a statement. Your lordship, I will come to the judicial from where he was produced also. I will come to that, your lordship. So now also again here, your lordship, the reflection time has been given to the concerned accused. I have satisfied myself that there is no police officer in the court or in any place there proceeding can be seen or heard except the above name. I now carefully explain a praise to the accused who has not been concerned in the investigation of the crime or in the arrest or production of the accused, that I am not an officer of a police but a magistrate, that he is not bound to make confession, that if he does make a confession, it may be used in evidence against him, that he should not say anything become other that have told him to say it, but it is at liberty to say whether he is really desired to say, that he could say nothing which is nature, and I have been fully explained, and that he appeared to me to understand them. In order to ascertain whether the accused is prepared to make a statement of his own praise, will be next examined as following. Question: do you know me? Answer of the accused, your lordship: no. Okay, I am magistrate. I have explained that he is not bound to make confession, your lordship. Any confession which may be used as evidence against him. Yes, I understand and fully aware. Are you under any pressure, influence either from police or anybody? No. Are you voluntarily ready to give confession? Yes. The recording of the statement. The statement of so and so, made in Hindi language by my name is so and so, my father name is so and so, I am by tribe so and my occupation so and so, he was a government employee. My home at so and so, so and so, so and so. Now, your lordship, statement, your lordship. I am so and so constable posted at Vijayanagar. I am to state that on 20 August 12, we had taken drink plus meat at resident of OC in the evening. Who are there in the party? Myself, ASI, SK Singh, OC Vijayanagar, Head Constable Chaturvedi, WT Staff Yadav, Sajung Driver, Constable SB Khan, and his wife. When the party was over? The party was over at around 8 p.m. Thereafter, what happened? Now he narrate everything. After the party was over, myself, Sajung, your lordship is the deceased person. Sajung, Mr. Khan and his wife went to Khan's quarter, where Sajung Driver was invited by Khan and family for dinner. After reaching Khan's quarter, Mr. Khan offered us Roxy liqueur, which is a local made, to me and Mr. Sajung. Sajung took half a glass. I was taking and took some 3 glasses. Sajung was offered meal by Khan's wife, but Sajung did not take it and washed his hand, spoiling the meal. Mr. Khan was annoyed and told Sajung that he should not spoil the meal. Rather, hearing his remark, Mr. Khan's wife got annoyed and indicated me to take him away. Thereafter, we, myself and Sajung Driver came out. Your lordship, Sajung is a deceased person. Out of Khan's quarter, as Mr. Khan was annoyed with the behavior of Mr. Sajung. So both of us came out and told Sajung that I would go to quarter straight. So I left him, Sajung, near police station. And I came straight to my quarter. My quarter was locked. My wife was at in-laws house. So I broke open, this may be noted. I broke open the lock and entered into my quarter. After 5-6 minutes later, Mr. Sajung came to my quarter and started insisting me to accompany him to Khan's quarter. After reaching Mr. Khan's quarter, I found the light lit off. So I told him to return. It would be around 10 p.m. or so. While returning to my quarter on the way, Sajung told me it is late, so we would sleep in my quarter.
I agree and told him to come. I offered him blanket and pillow and told him to sleep in the sitting room. I came to my room and was reading book with my torch. This is also noted, my torch light. After 30 seconds, he, Sajung, came to my bedroom and started talking unparliamentary talking my wife name. I became angry and pushed him. He then went back, came toward me and scratched my left hand with his finger. Then in defense, I gave a blow on his face. He fell down near the door and went up my bedroom. I was picking my torch light from the floor. Just then he entered my bedroom again with a dao, kukri, in his hand and attacked me with kukri, which I obstruct with my hand. The kukri dropped on the floor. I pick up the kukri and turn up. In meantime, he fell on me, which struck on his neck and blood started ozoning. Sajung fell down on the floor. I got nervous. Sajung was trying to get up. Then I caught hold of his mouth and cut his throat, which was already bleeding, so that he does not attack me again. What parliamentary word he was uttering about your wife? He, Sajung, took my wife gala lady's dress. He was smelling it and was telling me that he wished to keep my wife and that he would sleep with my wife, thinking that my wife is also in my quarter at that time. Where the kukri lying and how he, Sajung, got it.
This gala lady's dress.
Gala, your lordship, the wrapper usually, the mekla, your lordship, used by the local, the other people, and Galo as well, and other community. Where was the kukri lying and how is Sajung got it? The kukri was in the sitting room where actually the deceased was sent to sleep, your lordship. What did you do when he fell down lifeless? I dragged him down to back of my quarter. Your lordship, this may be noted, back of my quarter and threw the body in ditch around 30 meters away. Now, 8. I have studied carefully the provision of Rule 23 of the High Court General Rules and Circular Order, so and so, so and so. I believe that the confession was voluntarily made. It was taken in my presence in the hearing and read over to the person taking it and admitted by him to be correct, and it contained a full and true account of the statement made by him. And your lordship will kindly see in 10, the point number 10, the accused is forwarded to judicial custody. Properly compliance with the, your lordship, the 164 subsection 5 provision of 164, your lordship, of the CRPC. Now, your lordship, it is well settled that an accused can be convicted on the basis of the confessional statement. However, as a matter of prudence, the court must seek corroboration from the other circumstantial evidence. And however, it has further held that the same is not an invariable rule of law, considering fact and circumstances of each case. But here also there is sufficient collaboration. Now, your lordship, I have pointed out lock, torch, kukri. Your lordship will kindly come to the seizure list, your lordship. It's in page number. Page number 3 onward, your lordship. Exhibit 2, place of seizure, government quarter of Constable Kalentine, the accused house. Date and time of seizure 21/8/1200 hours. Case so and so. I so and so. Your lordship, description of seizure. Kukri, the weapon used in the offense. And this is the kukri, and the exhibit, paper exhibit is, your lordship, 1-2, his signature is there. And your lordship will again find in exhibit 3, page number 4, seizure. Description of, your lordship, seizure, page number 4, your lordship. Kukri was there. The description 1, Hawaii chapel 6 number red color 1, t-shirt color 1, red torch 1, track suit pant 1, full sporting 1, t-shirt color with blood stain 1, mosquito net 1, tusok 1, bound card 1, piece of small cloth 2, blanket red color 1, pillow cover 1, blanket blue, white, red from sitting room of so and so, broken lock 1 number, broken bucket red color. So now, your lordship, so far as this breaking enter into the house is corroborated because the broken lock has been recovered. Second, kukri also, the place of the used in committing the offense, that has also been recovered. And now, so far as, your lordship, their presence and both of them were last seen in the house of, he has explained, Mr. and Mrs. Kane.
That also corroborate, your lordship, we kindly come to this prosecution witness deposition number, your lordship, page 49, your lordship. This husband, this 4 and 5 is the independent witness, their husband, wife, they both have seen them last together. From there they left and the incident happened. On summon of this court, I am appearing before this court. I know the person is standing on the dock. He is Kalangtang. I don't remember the day and year. Probably it was month of August. Myself and my husband, Chow Binoy Ken, in the afternoon of the day, went to the house of OC of Vijayanagar police station. There were already 3-4 persons in that house. They consumed 1 full bottle Indian-made foreign liquor. The accused Kalangtang was also present at that time. However, he drank Roxy, local-made wine. By the 8 to 8:30 p.m., myself and my husband came back to our house. After 5 to 10 minutes, accused and deceased Let Sajung came to our house. I provide dinner to Let Sajung, but he did not took the dinner and simply washed his hand. The accused person was drinking Roxy and consumed a full bottle of it. At that time, in my house also, there after around 9:30 to 10 p.m., both of them left our house. In the next morning, around 7:30 a.m., accused along with his wife came to our house and was telling in loud voice that there was a lot of blood in his house. My house is located in police colony of the Vijayanagar, where the accused house is also located. The distance between our house will be about 200 meters. At that time, my husband was still sleeping. However, I wake up him. Meantime, the people of the colony, including the police personnel, gathered in the house of the accused. We also went there, but myself and the wife of the accused did not enter inside the house. We were standing near the gate of their house. Thereafter, myself and wife of the accused came back to my house. Later on the same day, I came to know that Sajung has died. In that night, there was a heavy rain, your lordship. This may also be noted, heavy rain. In that area, I don't remember whether I have given a statement to the police. Let Sajung was slightly drunk at time of their visit to our house. Let Sajung was not uttered any unparliamentary word or abuse language to me in that evening, nor there was any argument or fighting between the accused and the deceased. It is true, when they left our house in the evening, both were fine and good. I don't know whether Let Sajung used to drink regularly or not. I have not heard any quarrel between them in the past. They used to be a good friend. I don't know the past life of deceased. I don't know how Sajung had died and under what circumstances. This is one of the witness, your lordship, who have seen them together. And after that, your lordship, they left. And they went toward their house. And now the second is, your lordship, PW5, the husband.
Yes.
Yes, your lordship. Now PW5, your lordship, the husband of this PW4. I know the person is standing on the dock, page number 51, your lordship.
Yes.
standing on the dock. His name is Kalentang. We were working in the same department as police personnel and our same batch. It was in the year 2012, month of August, that probably 18 or 19, in the afternoon of that day, myself, S.K. Singh, the then OC of Vijaynagar, PS, two Major S.R. Yadav and Chaturvedi were playing card to pass our time in the house of OC, as there no much work in Vijaynagar. At around 4:35, I went to market to purchase a bottle of IMFL. Accordingly, I purchased a bottle, make Doyle rum, from the market to drink in the house of OC. When I returning for the house of the OC, I met Let Sajung on the way, who was coming from the opposite direction by holding a hen in his hand. By seeing the bottle in my hand, he requested me to give a peck from that bottle, on which I replied him that I cannot give him in that place. If you want to drink, you may come with me with the house of OC. Accordingly, he came with me in the house of OC with hen, which he was holding. Meantime, I also called my wife from our house, which is hardly 50-meter distance from the house of OC by that OC. By that time, accused Tang also came in the house of OC. I exactly not remember whether Mr. Mamai was present in the house of OC at that time or not. We drink that bottle, but accused drink one bottle of Roxy, which was given by me to him on his request. The hen brought by Let Sajung was also prepared in the house of the OC to eat with drink. At around 8:15 p.m., but we have not checked the time at that time. Myself and my wife had left for our house with some chicken for Let Sajung, who wanted to take dinner in my house. After 5 minutes or so, Let Sajung and accused Tang came to our house. My wife provided dinner to Sajung, but Sajung did not took the dinner. Instead, he was his hand. He was slightly drunk at that time. On the request of the accused, I given him one bottle of Roxy to him, which was consumed by him along in my house. At about 9:30-10 p.m., both of them left my house. On next morning, around 7:30, my wife wake me up from sleeping. When I wake up, accused, who is already in my house by that time, told me that there is a lot of blood in his house. On this information, I, along with the other staff of the colony, went to his house. My wife and wife of the accused also came along with us, but they did not enter in their house. They returned from the gate itself to our house. Then we entered in the house of the accused. The OC sir was the first person to enter, followed by Major and myself. I have seen lot of blood in the bedroom, as well as drawing room of the accused quarter. I have seen the blood in the floor, bed, mattress left of that room. I have also seen a long pant and shirt stained with blood in that room. I have also seen kukri, Nepali dao, with blood stain in the bedroom of the accused. By that time, it is learned that Let Sajung is missing, you know. Therefore, we start searching him. As Let Sajung was the staff of CO office, therefore, the staff of CO and the police start searching him. The dead body of Let Sajung was found by ALC of the CO office. The dead body was found at around 10:11 of that day. The dead body was found at the Deep George, which will be about 70 to 80 meters distance from the house of the accused. Dead body was taken out from the Deep George and was kept in the abandoned government quarter located near to that area. Then we have guarded the dead body till the next day. When the helicopter came to evacuate the dead body to Changlang District Hospital to conduct postmortem, I myself accompanied the dead body along with the OC in the helicopter from Vijaynagar to Changlang. The accused Tang was also accompanied to us. We all were in uniform as we are doing our duty. I have seen the dead body of Let Sajung. I have seen 2 injuries on his body. One on the neck, which was major injury, probably cut by that kukri, which we found in the house of that accused. Another injury at the forehead of the deceased, which seemed to be caused by a pointed weapon may be caused by point of that kukri. The accused was taken to custody at Changlang police station. When we came there by helicopter with dead body, later on he was taken to Miao police station. I have not seen the incident, but I have heard the deceased was killed by the accused. P Exhibit 4A is my signature, so and so, so and so. Your Lordship, now cross. I have given same statement to IO as stated before this court. It is true, I was told by Chingro Mamai that in that night, accused had sleep in his house. Your Lordship, accused was not sleep at the place of occurrence. He slept at somebody else's house. It is true, I cannot exactly say that the injury on the neck of the deceased was caused by that kukri. Same is with the injury on the forehead of the deceased body. It is true, I have not seen any sign of dragging of the body from the house of the accused or anywhere near the dead body. It is true, deceased Sajung used to drink regularly. No any quarrel will took place between the accused and the deceased in past. They used to be good friends. Accused might not have killed the deceased. It is true, the lungi seized in the case was brought by Singru Mamai from his house to police, which was worn by accused in the night of that incident, at time of his sleeping in his house. It is true, one piece of chappal was found near the post office of Vijayanagar. It is true, on that morning, accused told me that some 2-3 persons were sleeping in his house in the night of the incident. It is true, by hearing from the others that the accused killed the deceased might be wrong also. I have not seen any motive or reason for killing the deceased by the accused person. I have not heard any criminal record of the accused person. Now, Your Lordship, here also, Your Lordship, it is clearly corroborate with the PW4, Your Lordship, that they went there and from there they left. And from there, also, Your Lordship, one thing established that at that night there was raining. And Your Lordship, I have, Your Lordship, already pointed, Your Lordship, that accused stated in his confession that he dragged the dead body. And if it was raining, there is all possibility that dragging of the blood stain will not there. Because on the next day, the dead body was recovered. Now, Your Lordship, may kindly come to page 7. This is the sketch, rough sketch map, Your Lordship. It also corroborates with the statement of the confessional statement of the accused person. Your Lordship will see in H is the dead body, Your Lordship. Left side, H, dead body. And A is the quarter, government quarter of the accused person, Your Lordship. And it is in the back side only, Your Lordship. C is the way, road. So again, it corroborates, Your Lordship. In the back side, he dragged the body and he threw the dead body there. The minor discrepancies regarding, Your Lordship, meter, 20 meter, 30 meter, that will not affect the core of the prosecution case. Minor discrepancies will definitely be there, Your Lordship. And now, Your Lordship, so far as the conduct, Your Lordship, when this kind of offense are committed, the court has to take into consideration the ordinary course of conduct and human probability in the case, which is also a relevant factor, Your Lordship. At that night, where accused went, leaving his own house, Your Lordship, it will, inference can be drawn from the, Your Lordship, statement of PW3, Your Lordship. That is in page number 42.
Yes.
Yes, Your Lordship, this is the prosecution witness, usually where the victim resides. Usually, in the usual, ordinary days, Your Lordship. I know the accused is standing on the dock. His name is Kalantang. Once he was at Vijayanagar as Constable APP. In the year 2012, I was at Vijayanagar. I was working as LDC of the Circle Officer of the Vijayanagar. Late Sajung was the driver of CO Vijayanagar. Both of us used to reside together in my quarter. This may be noted, Your Lordship. On 28 2012, at around 5 p.m. in the evening time, when I was coming back to my quarter, Late Sajung and the accused Tang were coming back from the market and was just crossing my quarter. On my query, Late Sajung was telling me that they were going to police colony. In the evening, Late Sajung did not come back. Deceased didn't come back. Therefore, I went for sleep maybe around 8:30. Whole night was raining in that night. In the middle of the night, accused Kalantang came to my house alone. Accused came, Your Lordship. When I opened the door on his knock, he came inside my house. I asked him, where is Sajung? Accused replied me that he left the deceased near the police thana. To some extent, it also corroborates, Your Lordship. The other thing he has not explained. Only till police thana he explained. Accused Tang left my house toward the market. Now, Your Lordship will see the conduct. The accused Tang left my house toward the market by saying that his family is in the house of his in-law, which is located in the market side. Now, Your Lordship, see, after gap of 5-10 minutes, again accused Tang came back to my quarter and sleep with me for whole night. He's not went back to his own residence, Your Lordship. He slept with the person with whom the deceased usually reside. In the next morning, around 5 to 5:30 a.m., I wake up and went toward the police colony in search of Late Sajung. At the same time, accused Tang was already awakened from sleeping, but was still lying on the bed. At that time, nobody were wake up in the police colony and all are still sleeping. Therefore, I came back to my quarter. After coming back to my quarter, I started preparing my meal. As I have to go to my office on time, When I came back to my quarter, accused Tang was still lying on the bed. However, when I started preparing my meal, accused Tang wake up from the bed and went out from my quarter, maybe gone toward the market. After a gap of 1.5 hours, accused Tang came back to my quarter. This is the time he was accompanied by one of his constable friend. His name was called Kang. This time, both of them, Tang and Kang, was telling me that a person might have slept the night in the quarter of the accused Tang, but have left the quarter early in the morning, and there is a lot of blood stain spread in the room of the accused Tang. On the day time, I requested the staff of my office, including the ALC, to search the missing Sajung, who used to drink. Therefore, I advised them to search in the house where such drink used to sell. I personally also searched the deceased Sajung, but could not found. Lastly, we came back to the police colony as there was a blood stain in the quarter of Kaleng Tang. When we reached the house of Tang, police also came there. After seeing the blood stain spread in the quarter of the accused Tang, we thought that if this is the blood of a human being, the person will not be alive. After losing such huge quantity of blood, accordingly, with the help of police team, we started searching nearby the jungle and hills, as the police colony area located in the hilly and jungle area. After seeing for some time, the dead body of Sajung was found from the deep gorge from the main ground. The dead body was not very far from the house. Here it says, Your Lordship, the dead body was not very far from the house of the accused Tang, but I cannot say the exact distance. The dead body was picked up from the gorge and was kept near the quarter of the police colony, which was unused and damaged quarter. Then we sent a WT message to DC Changlang with a request to provide chopper to evacuate the dead body to Changlang. I have given my statement to the police and I have stated everything before the police, maybe on 23rd of the August 12. Helicopter came to Vijayanagar and the dead body was taken to District Hospital Changlang to postmortem. Before taking to Changlang by chopper, the dead body was guarded by us in place itself. The accused Tang was also helping us in searching of the deceased Sajung. I have personally seen the dead body from my own eye because we lifted the dead body from the deep gorge. I have noticed 2 injuries on the body of the dead body of Sajung. One at the forehead, which was not very large in size, seems to be caused due to striking. The second one on the front side neck throat of the deceased, which was very large, seems to be caused by sharp weapon. As the whole night was raining, the dead body was found in the wet, including the clothes. I have also seen that the police have seized some material from the accused quarter. Among them was one kukri, one torchlight, some clothes, which they packed in gunny bag. I have also seen one piece of chappal. I have also seen a black color t-shirt in the table of the accused quarter, which was the t-shirt of deceased Sajung. I know that the black t-shirt to be the deceased, as we reside together. I have also seen a red color bucket in the room of the accused, rest which is stated to be in the seizure list. I don't remember the P exhibit so-and-so are my signature in the seizure list. The M exhibit so-and-so is kukri available from the so-and-so. That means the exhibit has been duly proved. Now the cross. I cannot say that what time accused came to my house in that night, as I did not watch the time. At that time, my mobile was switched off. I cannot say the exact time. Might came around 10 to 10:30 of that night, but I am not sure. I cannot also say exactly by what time after searching the missing Sajung is early in the morning I came to my house. Probably I might have returned by 5:45 or 6 a.m. It is not the fact that when I was preparing my meal in my quarter after coming from the search of the missing Sajung on the morning, Kaleng Tang, who was sleeping in my quarter, had left my quarter with his wife. He alone had left my quarter. I don't remember whether I have stated before the police that Kaleng left my house with his wife in the morning only. It is true that I have given my statement before the magistrate, as it was already too long period. As such, I did not remember whether I have given the same statement before the magistrate or not. Suggestion: as the accused Tang was sleeping with you in your quarter that night, therefore the crime must have committed by somebody else. What do you say? I don't know. It is true on afternoon 28, 2012, I was coming back from the house of OC, which is located in police colony, after playing card with them. It is also fact that I came to play card with them at around 4:30 p.m. after my office hour. At the time of my reaching in the quarter of OC, there 3 persons were already playing card. They were OC, Major Chaturvedi and Kang, and I joined them. I left the place very quickly, probably by 5 p.m. I've stated before the police same thing, but I don't remember about the time. I don't remember if I have given my statement before the police that I went to quarter of the OC at 1 p.m. of that day. I also don't remember that I have stated before the police that by 4:30 we finished the playing card on that day. I don't remember whether I have stated before the magistrate that on the day I have spent about 3 hours by playing card in the house of the OC, but I must not have told the time by playing card either to the magistrate or to the police. At the time of my playing card in the house of OC on that day, accused Kalentang was not present. In my presence, there was no counting of money to find out who lost and who won. Now I remember it was Sunday, not the office day. After game is over, they were discussing to have drink in the house of the OC. As I did not drink, therefore I left the place along with the person, maybe Kang, who was going for marketing for them. On the way to my quarter, I met late Sajung, who was holding a chicken, who was crossing my house toward the police colony. I don't remember if I have stated before the magistrate that I was coming out from the house of OC after playing the card with the accused Kalentang. I don't remember whether I have given the statement thereafter we went to SIB camp. I might have said so. I also cannot say whether I have given a statement before the magistrate that when I was along with accused Tang was coming from the house of OC for SIB camp. On the way, we met the deceased Sajung and Kang, who were cross us and going toward the police colony, as it is too long to remember the same. It is true that the chicken which were carrying by the deceased Sajung was supposed to be taken to the OC. It is not true that I stated before the magistrate that I came to my quarter around 8 a.m. after searching the missing Sajung on the morning of so-and-so. I don't remember whether the wife of the accused Tang came to my house on the morning of so-and-so. As such, I can't say whether the Tang went out from my house with his wife or not. This is very clear. He's already stated that he didn't went with his wife. The signature shown to me before this court is my signature. I can identify the same which was signed before the magistrate at Changlang. The same is exhibit as court exhibit so-and-so. It is true, I have seen only one piece of chapel on that day and not both of it. I cannot say whether the seized kukri was used by the accused to commit the offense or not. I have not seen torch before this court. I have not checked the seized cloth where belonged to accused or victim, as it was already packed in a gunny bag. I have not seen the accused and deceased going together toward the house of the accused person. The deceased also did not told me that he will be sleeping in the accused in that night. I have not seen any quarrel or fighting between the accused and deceased in the past. I don't know any motive or reason of killing the deceased by the accused person. I cannot say the blood stain which I have seen in the house of the accused person was belong to whom. If the accused could have been killed the deceased, he could have run away from the area and could have hide the weapon of offense. He might have not done. It is a fact that I cannot say that the dead body found in that area was thrown or kept by accused person. It is fact that the deceased Sajung used to drink alcohol, but he did not use to fight others. I cannot say the deceased was killed by accused because I have not seen the incident. It is true, the seizure of the police was not led by the accused. No doubt, Your Lordship, the seizure of the weapon, the kukri, was not led by the accused because, Your Lordship, the accused was at that point of time was not admitting. Later on, it was confessed, Your Lordship. And Your Lordship will find my learned brother has pointed on the blood stain, Your Lordship, which was there. So, Your Lordship, in this kind of cases, Your Lordship, if all circumstances pointing on the guilt of the accused, then, Your Lordship, the blood which was found there, it cannot be disputed that it belonged to any other person because at that point of time, no one other dead body was found there. Then, otherwise, Your Lordship, the alternative possibilities would be there. But on that particular day, only one dead body was recovered. There is nothing in the record to show that any other person was dead body or any other person found to be with wound. Only from the deceased person. Your Lordship may kindly come to the post-mortem report, Your Lordship. The post-mortem report also, Your Lordship, corroborate with the whatever the prosecution witnesses stated, Your Lordship, the injuries, Your Lordship. Your Lordship will find in page number 14.
14.
Yes, 14, Your Lordship. Your Lordship will find in the assistant sergeant, opinion of sub-assistant sergeant, Your Lordship. Last, Your Lordship. In my opinion, the cause of death was due to cardiorespiratory failure due to hemorrhagic shock as a consequence following severe bleeding from cut throat caused by sharp edge, Your Lordship. The medical, Your Lordship, opinion also corroborate with the, Your Lordship, directly pointed that it was used by, caused by the lethal weapon. That is, Your Lordship, kukri itself, Your Lordship. And, Your Lordship, so far as blood stain is concerned, the supplementary charge sheet was filed, where, Your Lordship, as FSL report was produced, Your Lordship. If in, Your Lordship, page number 22. Your Lordship, the operating part is 26. Your Lordship may directly come to page 26.
Yes.
Yes. Your Lordship, in italic format it has been written. Now FSL, Your Lordship, find after 7, Your Lordship. Now FSL report received from FSL Guwahati through Constable S.K. Tiwari on dated so and so, which expert result examination. Exhibit number 030 so and so gave positive test for human blood of group B. Exhibit so and so gave positive test for human blood only, but their group could not be determined due to inconclusive result of the test. Exhibit so and so gave positive test blood only, but their origin could not be due to degradation of blood. Exhibit so and so gave negative test of blood. So now it is not disputed now, Your Lordship. It was blood only. And coupled with the circumstances, Your Lordship, the dead body was recovered from the backside of the residence of the this convicted person, and which corroborate with the confessional statement where he has said that after commission of the offense, he dragged the body about 30 meters away from the house backside, which clearly corroborate with the sketch map, Your Lordship, which has been exhibited. And Your Lordship, the injury which he has explained in his confessional statement is corroborate with the ocular witnesses who have seen the dead body, and from the medical evidence, Your Lordship, opinion as well, Your Lordship. And the kukri was recovered from the place of occurrence itself, Your Lordship. So now, Your Lordship, the evidence of the 4-5, which clearly, from where your inference clearly be drawn that they both left together from their house, and after that everything is happened. In between, Your Lordship, the incident caused. After that, committing the offense, accused came to the residence of the friend of the deceased person. From there, his conduct was not normal because he didn't went to his relative house, Your Lordship. He has not lead any defense evidence, Your Lordship. He went to this deceased friend house where usually reside with him, and from there he went out. He simply went out by saying that he is going to his in-laws place, but he didn't went there. Again, he came back and he slept there. In his confessional, he has clearly stated that I went there and I broke the lock because it was locked and my wife was not there, and lock was recovered from the place of occurrence, Your Lordship. So he entered, and the conduct, Your Lordship, he was not sleeping there, Your Lordship. If he went there and if on the same night it was found, then it can, Your Lordship, some other possibility could be there. But here the circumstances clearly pointed none other than the accused itself. So now, Your Lordship, I will conclude my argument with this by relying certain few judgments, Your Lordship. Firstly, Your Lordship, on this 164 statement, Your Lordship, regarding, Your Lordship, the recording of the statement by the empowered officers, Your Lordship, it's just a small. Then I will come on the, Your Lordship, confessional retraction of the retracted confessional statement. Lordship, 2003 8 SCC 180, wherein, Your Lordship, the Honorable Supreme Court has explained the extrajudicial confession and judicial confession. Here it is a judicial. Para, Your Lordship, may kindly come to 18, Your Lordship. Para 18, I will rely 18, 19, and 20, Your Lordship. May I read, Your Lordship? Confession may be divided into two classes, that is judicial and extrajudicial. Judicial confession are those which are made before a magistrate or a court in course of judicial proceeding. Extrajudicial confession are those which are made by the party elsewhere than before a magistrate or court. Extrajudicial confession are generally those that are made by a party or before a private individual, which include even a judicial magistrate in private capacity. In private capacity, it can be extrajudicial confession can be made. It also includes a magistrate who is not especially empowered. It's, Your Lordship, what I'm trying to, Your Lordship, pointing is, if it is empowered, then it will be a judicial confession. If not empowered, then extrajudicial confession. It is also include a magistrate who is not especially empowered to record the confession under the section 164 of the code, or a magistrate so empowered, but receiving the confession at the stage when 164 does not apply. As to extrajudicial confession, two questions arise: were they made voluntarily, and are they true? As the section enacts, a confession made by an accused person is irrelevant in criminal proceeding if making of the confession appear to the court to have been caused by any inducement, threat, or promise. Having reference to the charge against the accused person, proceeding from a person in an authority, and sufficient in opinion of the court to give accused person ground which would appear to him reasonable for supporting that by making it he would gain any advantage or avoid any evil or of a temporal nature in reference of proceeding against him. It follows that a confession would be voluntary if it is made by accused in a fit stage of mind, and if it is not caused by any inducement, threat, or promise which has reference to the charge against him. Proceeding from a person in authority, it would not be involuntarily if the inducement A does not have reference to the charge against the accused person, or it does not proceed from a person in the authority, or it is not sufficient in the opinion of the court to give the accused person ground which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil or temporal nature in reference to the proceeding against him. Whether or not the confession was voluntary would depend upon the fact and circumstances of each case, judged in the light of section 24. The law is clear that a confession cannot be used against the accused person unless the court is satisfied that it is voluntarily. And at that stage, the question whether it is true or false does not arise. If the fact and circumstances surrounding the making of the confession appear to cast a doubt on the veracity or voluntariness of the confession, the court may refuse to act upon the confession, even if it is admissible in evidence. One important question in regard to which the court has to be satisfied with is whether when the accused made the confession, he was free man or his movement were controlled by the police, either by themselves or through some other agency employed by them for the purpose of securing such a confession. The question whether a confession is voluntary or not is always a question of fact. All the factor and all the circumstances of the case, including the important factor of the time given for reflection, scope of accused getting a feel of threat, inducement, or promise must be considered before deciding whether the court is satisfied that in its opinion the impression caused by the inducement, threat, or promise, if any, has been fully removed. A free and voluntary confession is deserving of the highest credit because it is presumed to flow from the highest sense of guilt. It is not to be conceived that a man would be induced to make a free and voluntary confession of guilt. So, contrary to the feeling and principle of human nature, if the fact confessed were not true, deliberate and voluntary confession of guilt, if clearly proved, are among the most effectual proof in law. And involuntary confession is one which is not the result of free will or the maker of it. So, where a statement is made as a result of harassment and continuous interrogation for several hours after the person is treated as an offender and accused, such statement must be regarded as involuntary. The inducement may take form of the promise or of a threat, and often inducement involve both promise and threat. A promise of forgiveness if disclosure is made, and threat of prosecution if it is not. A promise is always attached to the confession alternative, while a threat is always attached to the silence alternative. Thus, in one case, the prisoner is measuring the net advantage of the promise minus the general undesirability of the false confession as against the present unsatisfactory situation, while in the other case, he is measuring the net advantage of the present satisfactory situation minus the general undesirability of the confession against the threat harm. It must be borne in mind that every inducement, threat, or promise does not vitiate the confession, since the object of the rule is to exclude only those confessions which are testimonially untrustworthy. The inducement, threat, or promise must be such as it calculates to lead to an untrue confession. On the opposite analysis, the court is to determine the absence or presence of an inducement, promise, etc., or its sufficiency, and how or in what measure it work on the mind of the accused. If the inducement, promise, or threat is sufficient in the opinion of the court to give an accused person ground which would appear to him reasonable for supposing that by making it he would gain any advantage or avoid any evil, it is enough to exclude the confession. The word appear to him is the last part of the section refer to the mentality of the accused. Now, Your Lordship, 19 and 20 is speak about extrajudicial confession, Your Lordship. Now, Your Lordship, I will rely only 18. The other I will. Now, your lordship, regarding now regarding your lordship voluntariness, your lordship, regarding if it is made at the belated stage, the court will presume that it's a voluntary one. Now, here in this case, as I pointed out, your lordship, the statement was retracted only during examination under 313, not at the early stage. Now I will refer to your lordship judgment 2020. This your lordship judgment 2020 volume 5 SCC 782. And para 27 and 28. The judgment entered in 1978 was reiterated here by the Honorable Supreme Court, your lordship, on voluntariness, your lordship. Because your lord, it has been the earlier judgment clearly said that first court has to see whether it was voluntary one or not. If it is voluntary, then court can proceed for the fact. If not voluntary, then court should not proceed, your lordship. Now, your lordship may kindly come to para 27 and 28. May I read, your lordship? 27. Further, it is essential to note that the petitioner failed to put forth any protest against the confessional statement, despite having multiple opportunities during the course of trial. This court has held earlier in Sankaria versus State of Rajasthan that retraction must be made by the accused as soon as possible. Otherwise, there would be a strong presumption of voluntariness in the confession. The confession in the present case was not challenged during the stage of framing of charge or over the course of examination of 47 prosecution witnesses, but instead only partly disputed through a letter written in secret just before the petitioner's examination under 313 of the court. It is thus evident that such retract at the flag end of the trial was not natural, but rather meticulously formulated, perhaps as a part of defense strategy. Hence, there remains no doubt about the voluntariness of the confession of 2011-2010 or it being unaffected by subsequent retraction. Here, your lordship, in this present case, wherein Supreme Court held that the belated, if it is in belated stage, it will be strongly presumed as a voluntary one. Here also, your lordship, before 313, they have tried to retract. But here, in our case, your lordship, during 313, it was retracted. It is very belated one, your lordship. So far as your lordship, voluntariness is concerned, your lordship, it has to be retracted at the earliest possible time, your lordship. Usually during framing of charge, but that has not been done. It was only during 313, and it was, your lordship, it is held in the many cases by the Supreme Court that retraction of the confessional statement as a matter of right, normally all accused, your lordship, exercise. But it is the court to decide from the fact and circumstances of the cases whether it was voluntary one or not. Your lordship, again, I will trouble your lordship to kindly open, again revisit the page number 61, your lordship. There I will, your lordship, point out one thing, that the accused was produced from the judicial custody, not from the police custody. Your lordship. It's in page number 61 in cross itself, your lordship. Only one line, your lordship. Then I will come to one judgment. Page 61.
Yes.
Page 61. Cross, Your Lordship. Mr. R. Singh was a police personnel. Accused was produced from judicial custody for recording of confessional statement. Not from police custody, Your Lordship. Now, Your Lordship, I will rely on judgment of the Honorable Supreme Court, where it has been held that the confessional statement cannot be rejected merely because 3-hour time reflection has been given. In that case, I will, Your Lordship, come to the judgment. In that case, Your Lordship, the accused were produced from the police custody directly. And magistrate has given 3 hours time. And that was the judgment rendered by our Honorable High Court only. It was interfered by the Honorable Supreme Court. I will rely the judgment. The judgment is reported in 1985. (1985) 3 SCC 291, Your Lordship. Para, Your Lordship, may kindly come to page 17, Your Lordship. 17, 18, 31 and 33 I will rely, Your Lordship. From 17 onward.
Para.
Yes, Your Lordship. From 17. Here, Your Lordship, initially, Your Lordship, the session court found that the statement was voluntary one and the trustworthy, and basing on that, Your Lordship, the accused were convicted. But later on, it was interfered by the High Court, and again, it was interfered by the Honorable Supreme Court. Para 17. This is the fact, Your Lordship. The learned session judge Dubrugarh, on a consideration of the evidence, convicted all the 4 accused and sentenced them as mentioned above, excepting the confessional statement exhibit so and so, 4 accused recorded by judicial magistrate, PW3 and other evidence in the case. The learned session judge has considered this confession in para 101 to 1010 of the judgment and has observed that there is nothing improbable or unbelievable in them, that they appear to be spontaneous and are stirred with vivid fact about the manner of commission of the crime, that they receive assurance in several material particular for the circumstantial evidence led it by the prosecution, and that they are all voluntarily and reliable, though it appear from the cross-examination of prosecution witness and from the statement of the accused recorded under section 313, they are retracted. Here also, Your Lordship, during 313, it was retracted. Now, Your Lordship, may kindly come to para 18. But the learned judge of the High Court rejected all the confession and the evidence of PW 10, 11, 16, and 25 regarding the identification of the accused in test identification prep. They have considered the confession of Henry in para 45, 55, 62, and 64 of their judgment and have observed that the judicial magistrate PW3 had failed to act properly in giving only 3 hours, Your Lordship, here to Henry for reflection before recording his confession. Exhibit so and so. They had further observed that though it is difficult to lay any hard and fast rule in Sarwan Singh so and so, it has been held that this court has generally speaking, when an accused is produced under police custody, Your Lordship, here, it is reasonable to insist upon giving him at least 24 hours for reflection. They have held that Henry confession statement exhibit 6 has obtained by coercion and is not voluntarily, and that it suffers from serious infirmity and cannot be acted upon. They have considered Sunil confessional statement exhibit 7 in para 74 and 76 of their judgment and found that he too had been given only 3 hours of reflection before his confession. He was recorded by the judicial magistrate PW3 on April 18, 1975, and that is not voluntarily, and therefore it is invalid in law. They have considered the confession exhibit so and so of their judgment and have observed that the judicial magistrate PW3, who recorded it on April so and so, had failed to see whether the accused was going to make the confession voluntarily. After comprehending the implication of his admission, they have considered the confession exhibit 9 of Naresh, recorded by judicial magistrate PW3 on April so and so in para 84 and para 87 and 88 of their judgment, and found that it has been made due to duress and inducement by the police and is not voluntary, and that is suffer from serious infirmity and cannot be acted upon. Here, Your Lordship, also, from the police, after when the accused were produced from the police custody, only 3 hours reflection time was granted. Even in that, the Supreme Court says that no, there is no any hard and fast rule. Though it is correct, Your Lordship, so far as the judgment which is relied by the High Court, there is no any hard and fast rule, but usually, Your Lordship, when accused is produced from the police custody, usually the magistrate court send the accused to judicial custody for reflection. Why am, Your Lordship, pointing it? Because in our case, the accused was produced from the judicial custody, and he
not from police.
Not from police custody, and he has further given time by the magistrate for reflection, and then after compliance of section 164, everything has been explained to him. Then his statement was recorded. And your lordship has also seen that in the statement, it meticulously he has explained everything. The same thing, your lordship, which Supreme Court emphasized here, that in their confessional also, they meticulously stated everything. Because in this kind of offenses, your lordship, because after 10 o'clock or within 9 or 10, if everybody slept, if the offense committed within 4 walls, it is not possible yet other person will come and give statement. It is from the circumstances only, your lordship, the conclusion has to be drawn. So, your lordship, even if reflection time is 3 hours has been given in this case, the Supreme Court has held that is sufficient, your lordship. It is all about voluntariness and truthfulness. There is no any, your lordship, mechanical way that if only 3 hours has been given, it has to be discarded. No, from the voluntariness and fact and circumstances of each case, your lordship. I have said, no, your lordship, I will rely on the two judgment, your lordship. That one is on retraction of confessional statement, whether court can convict the accused, what aspect has to be looked into, your lordship. Para, your lordship, 12 and 13, your lordship, I've marked in the top of the judgment. 2001 6 SCC 550 in para 12 and 13 only, your lordship. Learned judge of the High Court declined to act on the said confession mainly for two reasons. First is that the confession was retracted by the maker thereof, and second is that the recovery of the article was made prior to the confession. We may state at the outset itself that both reasons are too insufficient for overruling the confession. It is not the law that once a confession is retracted, the court should presume that the confession is tainted. As a matter of practical knowledge, we can say that no retracted confession is rarity in criminal cases. To retract from a confession is the right of the confessor, and all the accused against whom confession were produced by the prosecution have invariably adopted that right. It would be injudicious to jettison a judicial confession on the mere premises that its maker has retracted from it. The court has a duty to evaluate the evidence concerning the confession by looking at all the aspects. The twin test of confession is to ascertain whether it is voluntarily and true. Once those tests are found to be positive, the next endeavor is to see whether there is any other reason that stands in the way of the acting on it. Even for that reason, retraction of the confession is not a ground to throw the confession overboard. Here it clearly says, your lordship, normally in all the criminal cases, your lordship, they usually retract the confession statement. Now, so far as voluntariness is concerned, I have, your lordship, pointed out on during the 313 only. And on retraction, the plea he has taken, that the public pressure. Now the question here is, he was under the custody, judicial custody, he was protected. Since he has he has a right to retract the same, he has taken the defense. And regarding, your lordship, the statement given, the fact disclosed to the other prosecution witness, he has stated that 2-3 people were there. That was not been supported by any defense witness, because no defense has been adduced, your lordship. Because in that case, your lordship, there would be some alternative view. But no, your lordship, from the circumstances coupled with the material evidence, your lordship, it clearly pointed that it was none other than the accused only, your lordship. Now, your lordship, on conduct, I will rely on judgment, because after commission of the offense, your lordship, the accused went to place of the deceased person friend, from where, your lordship, where he made he has stated to the prosecution witness that he wanted to go to his in-law place, and he went went, he left from there, and after 15 minutes he came, and he didn't went to his own house to rest there, Your Lordship, despite the fact that it's nearby only. Here, Your Lordship, it has been held that the pre and post conduct of the accused has to be taken into consideration, because the ordinary course of conduct and human probability in the case is also a relevant factor, and it is amounting to providing, Your Lordship, missing link to complete the chain of circumstances. In para 4, Your Lordship. Nineteen 92 3 SCC, page 43, Your Lordship, I will read out para 4, Your Lordship. The narrative of the fact clearly established that the young beautiful lady, aged 22 SIC 20 years, who had intense and passionate love for the first respondent, yearning to have long and happy marital life, was exterminated hardly 1 year and 5 months after the marriage. As per doctor evidence, she died of asphyxia as a result of strangulation, and that 95% burn postmortem injuries were found over the body except the feet. Admittedly, this was done in the residential home of the respondent. The crucial question whether the theory of suicide propounded by the defense and as accepted by the High Court is true and believable. Undoubtedly, this case hinges upon circumstantial evidence. It is true to reiterate that in case founded on a circumstantial evidence, the prosecution must prove all circumstances connecting unbroken chain of link leading to only one inference that the accused committed the crime. If any other reason, hypothesis of the innocence of the accused can be inferred from the proved circumstances, the accused should be entitled to the benefit. What is required, not the quantity, but qualitative, reliable, and probable circumstances to complete the chain connecting the accused with the crime. If the conduct of the accused in relation to the crime come into question, the previous and subsequent conduct are also relevant fact. Therefore, the absence of ordinary course of conduct of the accused and human probability of the case also would be relevant. This court must weigh the evidence of the cumulative effect of the circumstances, and if it reaches the conclusion that the accused committed the crime, the charge must be held, proved, and convict, and sentence would apply. Now, here, Your Lordship, Honorable Supreme Court has emphasized on the conduct, Your Lordship, the post and pre-conduct, Your Lordship. Here in our case, Your Lordship, the accused, Your Lordship, normally usual course of conduct, the person should have stayed at his own residence, but instead of doing that, he's residing in some other place, and that too, he was not acting normally in the ordinary course. He went out somewhere and coming up after 15 minutes, Your Lordship, there.
Yes.
So that his conduct is not the ordinary course, ordinary one year, and it was the unusual one, Your Lordship, from where the inference can be drawn that something has happened, Your Lordship. The chain, it is an additional chain, Your Lordship. With that, Your Lordship, and moreover, Your Lordship, it is a conviction under 304. But, Your Lordship, since the state has not preferred an appeal for any enhancement of the conviction, I will not come to the whether the intendment was there or not, because it is also well settled that it is not the intention can be drawn from the class of weapon, the injury inflicted vital part of the organ, which will result in death of the person. That aspect is there, but I will not advance argue on that, since we are not here for, Your Lordship, convicting on this altering the conviction on 302. So for which that, Your Lordship, I will rest my case. My senior counsel will argue for the victim, Your Lordship.
He has covered everything, so I have nothing more to submit.
Yes.
And moreover, as a amicus curiae, my role is very limited. Lord.
You want to reply?
No, no, Lords.
Second judgment is reserved.
Deeply obliged, Your Lordship.
Yeah. Number 24.
And this is appeal, Your Lordship.
My application.
This is
My-
IF for suspension of sentence.
My lord, this is yes, criminal appeal, my lord.
No, IF for.
IF for suspension.
My lord, yes, I have for suspension of.
How
So
much
my
of
lord,
that?
I have passenger many times that when meta race in such stage, therefore my lord, so far the IA has not been disposed. So if my lord, if we go through to the main case, so far my lord, IA has not been disposed on the ground that the paper book has already prepared. But my lord, today I will press the lordship to dispose of the IA because if we go into the merit of the case, it will take at least, my lord, 1 to 2 hours. So it will not cover today.
He was convicted on section 376.
376,
My-
Your Lordship, rape, Your Lordship.
And I will demonstrate, my lord, the show part, the 376 and the 376, and I have been, my lord, sentenced of 10 years. But my lord, at the relevant point of time, without going into the merit of the case, even if it is assumed that also, this is the, my lord, incident of 10 January 2006. So, my lord, on the date of the incident, my lord, the punishment for 376 was, my lord, 7 years. Now, by the criminal amendment of 2018, since from the 21st April 2018, my lord, this punishment become 10 years. But, my lord, carelessly, my case has been, my lord, carelessly, my lord, passed that the, on the relevant point of time, that is the 10 years and thereby,
It was 7 years.
yes,
Minimum is 7 years, Your Lordship. It can go to the life also. So minimum.
Oh.
up
10
to
10
7 years, that was the.
And Your Lordship, moreover, the victim side is not present today, Your Lordship. Since it's a rape case, Your Lordship, the amicus was appointed.
Where is the amicus?
Amicus morning, Your Lordship, he was
Ah,
there.
he was here.
Because this case was
also.
splitted, Your Lordship.
So, my lord, in fact, my lord, on the, just on the presume that this be the case of the amicus curiae on the ground that this should be most probably POXO. But that was the wrong assuming, my lord. In fact, this is the case of 376 only. Even
Not
amicus
POXO.
curiae was also, yes, not the POXO case.
Not the POXO.
So amicus curiae was also not required. So
Oh.
at this instance, my lord, my prayer would be, my lord,
How many days he is in custody?
IAB, my lord.
No.
Your Lordship, amicus now is available.
Yes.
It's amicus.
How many days he is in custody?
My lord, since the judgment, my lord, since the date of judgment, that is the 29/8/2022, until then, I am inside the custody, my lord. Because, my lord, the IA has not been disposed of.
Only 3 years.
3 years.
Only 3 years. It's a rape, Your Lordship.
Where is the FIR?
My lord,
FIR pays 2 and 3, Your Lordship.
if we, my lord, go to the paper book,
Page 2 and 3. Your Lordship, find in 1, Your Lordship. Page number 1.
Page number 1.
Yes, Your Lordship.
my lord, page 1.
Is she a lady?
My lord,
What is the name of the accused?
Your Lordship, there is 2 accused, Your Lordship.
There is-
Lady part, Your Lordship, remember, this morning it has been splitted. And
Oh,
she was convicted for 6 months only imprisonment.
Oh.
And here he is the co-accused. His name is not there in the FIR, but there is a clear allegation of rape, Your Lordship, in the FIR itself.
Okay.
I was being tortured for 20 and 2 days, and unknown person raped me in my employer residence on her insistence. This is there.
so at this instance, whatsoever, my lord, I have a good case to establish that this judgment was error, my lord. So before going into the merit of the case, I pray for the honorable court to, my lord, dispose of the IA. So I may be allowed to, my lord, remain on the previous bail, my lord. Just to dispose of this IA, my lord.
But unknown person raped me. What is the statement under 164?
160?
My lord,
164.
This unknown person is, my lord, me. And
Your lordship,
in the 161 statement or the on 164 and even in the deposition in 313, my lord, this accused person has never admitted, my lord, any offense.
No, what is the 164 statement of the victim?
Yes, my lord, it is important to bring the notice of this honorable court. 164 statement of the victim has not been, my lord, placed in the.
Actually, it has not been annexed. It's there in the
annexed
court
in
record,
this,
Your
my
Lordship,
lord,
but not in our paper.
Which is very important, my lord.
It is not in the paper book.
Yes, in paper book, they have
In the
not annexed
paper-
164 statement of the victim, Your Lordship. Only 164 statement of the accused person, Your Lordship. Confession statement.
Oh,
So, my lord,
And yes,
yes.
Your Lordship, the victim is the
160
maid, Your Lordship. Maid, home servant, Your Lordship. Maid, you know, she was working at the place of. Yes, yes, maid.
Despite that the 164 statement is in my lord books.
Give it to me.
Your Lordship is in there, Your Lordship, petition is there, Your Lordship. Your Lordship perhaps is there. Page number 51.
55, 51, 55. This is the vital document for the argument point of view, my lord.
Here he named the accused, Your Lordship.
Oh.
Kabuk Parme.
What is her age?
She
My
was,
lord, hard age was, my lord, not.
she was minor, but at that point of time, POCSO was not come into force, Your Lordship.
Oh.
POCSO came into force in the year 2012.
Oh.
This is the incident.
Case of 2006.
2006. That is why it is not booked under POCSO Act.
Oh.
Many minutes, let me. Minutes.
This is not her statement. Oh. Yeah, 164 statement of the girl. See, the 164 statement of the maid, the victim.
Victim is in
Man.
page 51, Your Lordship. Type copy.
Calculate.
Yes, Your Lordship. May I read, Your Lordship?
Just a minute. What is her name?
Her name is Srimati Pinky Bumij.
Pinky Bumij.
Pinky Bumij.
Oh, yes. Yes.
Yes, Your Lordship. May I read, Your Lordship? The deposition of so and so, 15 years here also 15 years it says. I came with my uncle Mr. Durga Kamakar to work in ONT State as State East Siang District on August 2005. After a few days, the JE of the T State Sri Christopher Tirkiri, Sardar of Donipolo T State, asked me to stay at Pasigat to work for his son Bipin, who was studying at class 12 at Pasigat. I was reluctant to go, but he forced me to go for a few days only. Then Mr. Makpel Megu and Srimati Yasumtagu, co-accused, came to fetch me from the T estate. From then I started staying there at the residence of Sri Yasumtaku, where the Jai's son Bipin was staying as a tenant. After a few months, the Jai Sardar Sri Christopher came and took away his son, but he did not take me back along with him to the tea estate. Few days before Christmas, my master Srimati Taku charged me for stealing rupees 10,000 from her. I denied having stolen the money. She then beat me with a stick. Mr. Makpel Megu came just then and hearing the matter without asking me anything, he also started beating me. Then they tied me up with a rope and every day beat torture me. Sometimes they pour water over me, also put hot burning coal. They used to put itchingly pujli patta or language over my body and then pour cold water over me. Sometimes they used to smash chili and rub it over body's wound. I got wound all over my body. After a few days in the month of January, one Sri Kabuk Parme, here you know, present, came to the residence of Mrs. Taku and inquired if they recovered the money from me. He volunteered to recover the money from me. My mistress agreed, saying that she was handing me over his hand for the day. Then Mr. Parme beat me with a big stick near my master's. After they left the house, he closed the kitchen door and then raped me. I was crying all the time. After raping me, he tried to hang me after tying a rope around my neck. Then Mrs. Taku and Megu came back. Then in the evening, they all tied my hand with a rope and tied me behind a scooter. Kabuk Parme then dragged me with the scooter for a few meters. After some time, I became unconscious. Then they sparkled water over me. Next 2 days, I was not tied with rope. On 10 January 2006, police came to the house, took me to the police station, then admitted me in the hospital.
And what is the medical report?
Medical report, Your Lordship. Your Lord, in paper book, page 4, 5, Your Lordship. Page 5.
Yes.
Well, I have the last item 28.
Which one?
28. It may
Item
not,
number 28.
yes, well, it may not be possible. The additional PP says he has to reach somewhere around 4:30.
Okay. I also have a meeting today.
Yes, well, kindly fix it on Monday.
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 Item number 28.
28.
I'll list this matter on Monday.
Grateful.
Okay. Medical report in what?
Your Lordship, in page number 5. This is medical page, Your Lordship. The finding is there in page 6, Your Lordship.
Yes, number 6. Opinion.
May I read, Your Lordship? General examination and development. Bulba A. Libya majora, B. Libya minora, well developed, hymen perforated, Your Lordship. Vagina, no tearing recently. Vagina, no discharge, normal. Your Lordship. Here, Your Lordship, 8 and 9, it said painful with leg cooperation. Operative, no injury detected. And Your Lordship, opinion. As per the report received from Department of Pathology, Pasika, the microscope examination detect smart found negative. It's not required smart to finding of the sperma.
So in total, the medical report was negative.
Not negative. It's hymen is perforated, Your Lordship. Meaning thereby it's a teared, Your Lordship. Not intact.
Wife is on bail.
My lord?
Not Your Lordship, the co-accused, the lady, against whom there is an allegation of assault, physical assault. For physical assault, Your Lordship, his sentence has been suspended because he was convicted only for 6 months, Your Lordship. Here he was convicted for 376, Your Lordship, for rape.
376, 10 years. So, my lord, what is the gist in the impugned judgment is, my lord? That on the basis of the statement of the victim only, what the learned court found that there was no enmity between the victim and the accused. Therefore, there is no possibility that the accused can lie, victim can lie against the accused person. That is the main turning point that why I have been convicted. But that is why, my lord, the statement before the 164, statement of the victim itself revealed that he beat me Yes, I admitted I was there and I beat her. And at the same time, as per the allegation of the victim is that I am the person who made her unconscious by dragging her to the motorcycle, scooting mallet. So there is a serious allegation against me that I have beaten her and physical torture to her. But this judgment has reflected there is no enmity established between the victim and the accused, and that is why the statement of the victim cannot be. That is why the statement of the victim is relied. That is, victim cannot be lie against the accused person. That is the main crux of the judgment, man. That is why I am saying that, my lord, the important document, vital document for defense purpose has not been, my lord, annexed in the paper book, though that is in my.
Your Lordship, from the medical report, the inference can be made that the
Though I have annexed it.
sexual assault cannot be ruled out, Your Lordship. Because it says purported that is matter to be decided by this court and which has been decided by the trial court. So, Your Lordship, from there, it cannot be said that sexual assault is ruled out, Your Lordship. And Your Lordship, so far as the enmity is concerned, if there is absence of enmity, then veracity of witness cannot be doubted, Your Lordship.
So, my lord, it will take my lord, certain time to dispose of the entire at this stage, my lord.
Mr. C. Modi, depending for the applicant in the I, make the order in the I. Heard Mr. T. Ate, we learned the difference from the prosecutor of the state of Assam. Heard Mr.
H. Lam.
H. Lam. Lampu. We learned the amicus curiae, it will be preparing for the informant. This application has been filed under section 389 of the Code of Criminal Procedure, praying for suspension of sentence and for releasing the applicant on bail. The applicant, Sri Kabuk Parme, was convicted and sentenced to undergo rigorous imprisonment of 10 years by the learned Sessions Judge Pasighat in Sessions case number 195 of 2012. He was convicted under section 376 of the Indian Penal Code. Mr. Ate has submitted that the medical report shows that the hymen of the victim was found to be perforated, and therefore the allegation of rape cannot be straightway ruled out. I have considered the submissions made by the learned counsels of both sides. The petitioner has been in judicial custody since
Judgment 28/9/22. 29/8/22.
Therefore, this court is of the opinion that his prayer deserves to be allowed. Therefore, the sentence imposed upon the present applicant, Kabuk Parme, by the learned Sessions Judge Pasighat in Sessions case number 195 of 2012 shall remain suspended till disposal of the connected appeal. The applicant, Kabuk Parme, is allowed to go on bail of rupees 25,000 with a surety of like amount, with the satisfaction of the learned Sessions Judge Pasighat. With the aforesaid direction, the interlocutory application stands as follows.
Last one.
In the main appeal, lawyers them saying, C. Modi, T. H. Lampu. Paper book is ready. So list after 2 weeks for hearing.
Your Lordship, after, maybe after 4 weeks, Your Lordship.
List after 4 weeks for
Yes,
hearing.
yes. Deeply obliged.
All right.
Very nice. Okay.